Where's your list of decisions?
Decision, Lordship, I have already given to the court master. And I have also cited some of the decision in paragraph 18. Paragraph, Lordship, 16 and 18 I have cited. Regarding the dying declaration, Lordship. Lordship, may kindly have a look at page 9.
We have
Yes, Lordship, that is one. That is why I have to. Lordship, may I kindly come to the list of argument. FIR at page 4 and 5 of the paper book.
yes.
The informant Saurang Basumatari has alleged that at around 5 p.m. when he was not at his home, his father and the said accused were roaming around together, and thereafter they went to the house of the accused, where an altercation followed by quarrel took place between them. Then the accused suddenly stepped on various parts of his father's person with dagger and caused grievous injuries. As a result, his father became unconscious and kept lying in the house of the accused. This is very important, Lordship. Kept lying in the house of the accused. PW 6 and 7 and 9 deposed that victim was lying in an injured condition in the compound of the victim. If the victim was injured was lying unconscious in the house of the accused, then how come he went there to his own house? Therefore, subsequently after arrival of at Swagat Hospital, his father died. One of the witnesses deposed that he was dead in his compound, Lordship. That I will come, Lordship. There was no eyewitnesses. There was no eyewitnesses. In the FIR, it has been stated that the complainant father was unconscious and kept lying in the house of the accused. How come the victim reached the house? This is very important. Now, Lordship, if your Lordship comes to the deposition of PW1 at page 8 and 9. He stated that on the day of occurrence, that is 3/9/2009, he was at Disney. Around 5 p.m., his mother, Sujola Basumatari, informed him over phone that accused Lena Basumatari has stabbed his father. But that Sujola Basumatari, PW9, she never stated that about never uttered the word Lena, the accused name, Lordship. Never. Dagger and reached home. The victim was taken to Swagat Hospital by 108 ambulance. He came to know that his father had died. In cross, he has stated that he do not know if there was a fight between my father and the accused. It is not a fact that I did not witness the occurrence and lost the case on false ground. He himself has stated that he was in Disney. How come he has seen the occurrence, Lordship?
You don't go according to your written argument.
Lordship.
Go according to the
paper book.
Now, in the cross, Lordship, I was not on false ground. If he was in business, how come he has seen the occurrence, Lordship? Now, Lordship, I will take your Lordship to the deposition of PW9 at page 24. Who was the first person to see the victim? Page 24. Lordship got it. Wife of the victim, Lordship. I know the accused person in the dock. His name is Lena Goyari. The name of his father is Tenta Basumatari. The informant Saurang is my son. The occurrence took place in 2009 on 3rd September. On the date of occurrence at about 4 or 5 p.m., I went nearby river to take bath. Well, while I came back after taking bath, I saw my husband in a serious injured condition nearby my house. He was blood-bathed. I do not find anyone nearby the place of occurrence. He did not find anyone nearby the place of occurrence. When I came near the body of my husband, he was still alive and asked me to give him water. But when I came back with water, my husband was not in a position to speak. I asked my husband about the assailant, but he could not state. When he was taken to Shwagat Hospital at Bongaigaon, he was alive, but not able to speak. Immediately on arrival at the hospital, he expired. Police went to the hospital and did the inquest of the body and forwarded the same to the for postmortem examination. My son lodged FIR. Police recorded my statement. The witness has been declared hostile, and she is allowed to be cross-examined by the prosecution. She was the only person who first saw the victim lodging, and she was. There is nothing, no explanation by the learned court below, trial court, why she was declared hostile. And the person, the victim was, first he asked for a glass of water, and thereafter he could not able to speak Lord. And to bring the water, it took hardly 50 seconds or something, Lordship. Thereafter he did not able to speak, Lord. Now I will take your Lordship to the deposition of the PW 6 and 7, Lord. 6 is the on the basis of their deposition, the learned trial court has convicted the appellant, Lord. At page 18, Lordship, deposition of PW 6. Lordship, got it. I know the complainant. I know accused Lena Basumati. Around 4 p.m. on a day about 3 years and 3 months ago, I was at home. Then I heard the accused Lena Basumati has stabbed Ganesh Basumati with knife. Shamram Basumati, brother of Ganesh Basumati, gave the information. Then Shamram Basumati, if he has given the information, why he was not examined by the prosecution? He was not examined by the prosecution. Give me the information. I immediately came to the residence of Ganesh and saw Ganesh lying in an injured condition. I saw cut injuries in the chest of Ganesh. Blood was coming out. On being asked, Ganesh told us that accused Lena had injured him by stabbing him with knife. At that time, there were many people in Ganesh house. Ganesh was taken to hospital by 108 ambulance. He died on the way. Doctor examined surgeon. If there were many people, that those who were present at that time, why they were not examined? And no whisper has been made who were present. When the victim has told them that Lena has stabbed. In the cross lordship, I do not witness the incident. Police interrogated me in connection with incident. In my statement to the police, I did not say that Shabram informed me that Lena had stabbed Ganesh with knife. Why he has not stated that to the police that Shabram has informed him that Lena has stabbed Ganesh? And the time factor lordship, if your lordship has already gone through the deposition of the PW9, the time factor is lordship 4 to 5 p.m. and here he has stated that it is about 4 p.m. And that the water which the victim was has asked for to his wife PW9, this time factor is important, Lord. Because moment she came with the water, he could not able to speak.
How come?
Then how come he has that PW6 has deposed that he has told that Lena has stabbed? Cannot be known. And that was declared as dying declaration by the learned trial court. In my statement to the police, sorry, it is not a fact that accused Lena did not kill Ganesh by stabbing him with knife. It is not a fact Ganesh had died before I reached the place of occurrence. Yes, Lord. Now, Lordship, PW7 at page 20. Same deposition, Lord. And the PW7 is the mother of the victim. The complainant Shaurang Basumati is my son. It should be grandson, Lordship. I know accused Lena. We are from the same village. The incident took place around 3 years ago. Around 4 p.m. I went to Lucky Bazaar for shopping. She was not there, Lordship. She went to Lucky Bazaar for shopping. While I was in market, Sumitra informed me my son Ganesh had been stabbed by accused Lena. Sumitra informed me. Then Sumitra, if Sumitra has informed her that Lena has killed, then why Sumitra was not examined, Lordship, by the prosecution? She was also not examined. Neither the Sambram Basumatari was examined, nor Sumitra has been examined. She might have been the eyewitness to the occurrence. Therefore, she informed that Lena has stabbed, but she was not examined by the prosecution. My son Ganesh had been stabbed by accused Lena. On getting the information, I immediately came home. I saw Ganesh lying in the courtyard in an injured condition. I saw injury in his chest and both hands. Blood were coming out. At that time, Ganesh was in a position to talk. On being asked, Ganesh told us that accused Lena has stabbed him. Ganesh died while he was being taken to hospital. Now the cross part loss it is important. It is not a fact that I did not say in my statement to the police that Sumitra informed me that Lena has stabbed my son Ganesh with dagger. If the PW7, the mother of the victim, has stated that Sumitra is informed, then why Sumitra was not examined also by the prosecution?
She being the mother,
And she being the mother, she is an interested person. It is not a fact that accused Lena did not kill my son Ganesh by stabbing him with dagger. It is not a fact that Ganesh died before I reached the place of occurrence. It is not a fact that Ganesh did not tell me that accused Lena had stabbed him with the knife. Now, Lordship, the
P4, hearsay.
3-4 are hearsay evidence, Lordship. Now, Caesar witness, Lordship, it is
PW5.
PW5 at page 16, Lord. Accused Lena Basumatari is my nephew. Complainant Shaurang Basumatari is my husband of wife's elder or younger sister. Ganesh Basumatari, the father of the accused, had died around 3 years ago. When police came to our village, I came to know that Ganesh Basumatari had died. Police took me to the residence of the accused. Police seized one dagger from my house, and I put my signature on the seizure list as a witness. Exhibit 3 is the seizure list, and Exhibit 3(1) is my signature. Today I have seen that dagger in the court. Material Exhibit 1 is the said dagger. Now, Lordship, if the police took the PW5 to the house of the residence of the accused, then how the dagger was seized from the house of the PW5, Lordship? In the cross, Lordship, I do not witness the occurrence. I came to know about the occurrence only when the police came. The dagger was found on the road in front of our house. I do not know as to whom the aforesaid dagger belongs. I do not know what is written in the seizure list. It was not read over to me. Now, in the deposition, he has stated that dagger was recovered from his house. And in cross, he has stated that dagger was found in front of their house, in the roadside in front of his house. But there is a material contradiction in all the witnesses, Lordship. Now, Lordship, another seizure witness, PW8 at page 22. Page 22, Lord. I knew this is Ganesh. The incident took place around 3 years ago. Police seized one dagger from the house of Tegar Narajari. At that time, I saw the accused in the house of Tegar Narajari. After seizing the dagger, police prepared the seizure list and I put my thumb impression there. Today, I have seen the said dagger. Today in the court, now cross, Lordship, I went to the house of Tegar Narajari just after police had arrived there. I saw blood sticking in the dagger, Lordship. This is very important, blood sticking in the dagger. I do not know what is written in the seizure list. I do not see the place of Tegar's house, where from the police got the dagger. That the dagger which he has seen, it was a blood sticking also. But that dagger, neither the dagger nor the fingerprints of in the dagger was sent to the forensic for test
Whose blood?
to determine come to conclusion whose blood is,
Whether it was the mother or the mother.
whether it was a murder weapon or not. It was not sent to the forensic.
PW. Okay. That's the evidence.
PW10 is hearsay evidence also. I am not going.
PW11.
Now I take your lordship to PW11 at page 27, which is the IO. Okay. On 3/9/2009, I was working as an attached officer at Bijli Police Station. That day, when officer in charge of Bijli Police Station received a written SIR from Chirang Basumatari, he registered Bijli PS case number so and so and entrusted me with the charge of investigation. On 4/9/2009, I went to Swagat Hospital, Bongaigaon. The dead body was there. I had inquest on the dead body in the hospital itself and sent the dead body to RNB Civil Hospital to Prajar for post-mortem examination. I obtained signature of the witnesses in the inquest report in the hospital itself. Thereafter, I went to visit the place of occurrence. I prepared a sketch map. After visiting the place of occurrence and examining the witnesses, on 7/9/2009, I arrested the accused Lena Goeri alias Basumatari after interrogating him. When he was interrogated, he said that he would show the dagger with which he had committed the incident. Thereafter, I went to the house of Tega Najari along with him. And as shown by Lena Goeri, I seized the dagger from Tega Najari's house in presence of witnesses. Exhibit 3 is the scissor list and Exhibit 3(2) is my signature. Thereafter, I sent the accused to the court. I called the postmortem report. After completion of the investigation, I submitted the charge sheet against accused Lena Goeri, alias Basumatari, under section 302 IPC. Exhibit 4 is the charge sheet and Exhibit 4 is my signature. Now, the cross is very important. Law. Around 9:45 p.m. on 3/9/2009, I was entrusted with the charge of investigation. I reached Swagat Hospital at about 9:45 a.m. on 4/9/2009, and there I met the accused.
Yes, important.
This is very important. There he met the accused. If the appellant has committed the offense, he would have fled away. He would have fled away. Why he was present in the hospital? Therefore, Lordship, the Lala trial court, what he has held about and has convicted the appellant, it's absolutely perverse. Lord. I met the accused. Village headman had Lordship. I took their signature on the inquest report as witness. The inquest report was prepared in their presence. At 1 p.m., I sent the dead body to RNB Civil Hospital for postmortem examination. Around 3:15 p.m., I went to the place of occurrence. A section of so-and-so battalion also went with me. Sujola Goeri, the wife of the deceased, showed me the place of occurrence. I recorded the statement of witnesses at the place of occurrence and in the hospital. I recorded the statement of Sujola Goeri, Gogo Basumatari, and Khagen Basumatari at the place of occurrence. I prepared the sketch map at the place of occurrence itself. On the north of the place of occurrence, there is garden of betel nut and other trees, village road in the south, Gagaram Gairi's house in the east, and Bhavani Basumatari's house in the west. The accused was apprehended by the villagers on 6/9/2009. Now, in his deposition, he has stated that on 7/9/2009, he has arrested the appellant, accused person. And here in the cross, he has stated that the villagers have apprehended on 6/9/2009 and handed over to the police station. So there is material contradiction, even of the IO lordship. I was on law and order duty on that day. The distance between the place of occurrence and the place from where the dagger was seized is about 5-6 kilometers. At the time of going to recover the dagger, I took Tiklu with me as witness. There was no blood stain. If PW6 has stated that there was a blood stain in the PW8 has stated that there was a blood stain in the dagger. But here the IO himself is stating that there was no blood stain in on the dagger that I seized. There was no blood stain. I did not take the fingerprint of the accused and the one of the dagger. I did not remember whether I gave the copy of the seized list to the owner of the house or not. It is not a fact that the seized dagger is not one related to the incident and that the dagger belongs to the owner of that house. If we is stating that the dagger is related to the incident, then why it was not sent to the forensic laboratory for examination? And he himself is stating that there was no blood stain. And PW8 has stated that there was a blood stain. PW12 Lordship at page 30.
He is not the medical officer.
He is not the medical officer. He is only identified.
Where?
The doctor has conducted the postmortem. He was not examined. The ward boy has been examined, Lord. PW12 at page 30, Lord. I have been working at RNB Civil Hospital since 1989. I am acquainted with Dr. Avani Kalita, who was working at RNB Civil Hospital, Kokrajhar. I know the signature of Dr. Avani Kalita. In the year 2009, Dr. Avani Kalita was working at RNB Civil Hospital, Kokrajhar. Exhibit 5 is the postmortem examination report prepared by Dr. Avani Kalita. After postmortem examination, exhibit 5.1 is the signature of Dr. Avani Kalita, which I know. At present, Dr. Avani Kalita's whereabouts not known to me. As per direction of the superintendent of RNB Civil Hospital, I have approached to depose. Exhibit 6 is the authority letter issued by superintendent of RNB Civil Hospital. In cross lordship, Dr. Avani Kalita was working at RNB Civil Hospital since 2006, but I could not remember when he left the hospital. So if the postmortem was done by Dr. Avani Kalita and the deposition was given by one Maheshwar Mahilari, the doctor was not examined. Now,
My statement under.
my statement under 313 CRPC at page 32.
Denial, complete denial.
Complete denial, Lord. Lordship got it.
Yes.
PW1 Sri Shamarang Basumatari has deposed that on 3/9/2009 he got information from Sujala Basumatari that you have stabbed his father with dagger. What do you want to say in this regard? He has adduced false evidence. I do not stab him. Then page 33, Lordship. Question number 2. PW2 Gozen Basumatari has deposed that Ganesh's mother told him that a quarrel had taken place between you and Ganesh Basumatari, that you had stabbed Ganesh Basumatari with knife and that he had died. What do you want to say in this regard? I do not know about it. PW3 Sri Maneshwar Basumatari has deposed that you have stabbed Ganesh Basumatari with dagger and Ganesh Basumatari died. What do you want to say in this regard? He has adduced false evidence. PW5 Sri Rangram Narjari has deposed that on a day around 3 years prior to his adducing evidence, police took you to the house and seized the dagger. What do you want to say in this regard? He has adduced false evidence. PW6 Sri Khagan Basumatari has deposed that one afternoon around 3 years prior to his adducing evidence, he heard that you had stabbed Ganesh Basumatari with dagger, that he immediately went to the house of Ganesh, that he saw Ganesh lying in an injured state and that later Ganesh Basumatari died in hospital. What do you want to say in this regard? He has adduced false evidence. PW6 Khagan Basumatari's father deposed that when he asked Ganesh Basumatari, he said that you had injured him by stabbing him with knife. What do you want to say in this regard? I did not stab Ganesh with knife. PW7 Srimati Gogo Basumatari has deposed that at about 4:05 p.m. on the day around 3 years prior to her adducing evidence, she got information that you had stabbed Ganesh Basumatari with knife. That she immediately came home on getting the information and saw Ganesh lying on the courtyard. That when she asked Ganesh, he said that you have stabbed him with knife. And later Ganesh Basumatari died in hospital. What do you want to say in this regard? I do not know about it. PW10 Sri Bolen Boro has deposed that on a day around 5 years prior to his adducing evidence, he had heard that you had killed Ganesh. What do you want to say in this regard? I do not know. PW 11 Sri Kaneshwar Kalita has deposed that during the investigation on 7/9/2009, he arrested you, and when he interrogated you, you showed in Tegas Narjari's house the dagger with which you committed the occurrence, and that he seized the dagger in presence of witnesses. What do you want to say in this regard? He has said it's false evidence. This is the ILOC. What was the issue over which the quarrel took place between you and Ganesh? There was no quarrel between us. There was no quarrel. Bro. From where did you get the dagger? I do not know. Where did you get to go after stabbing Ganesh? I did not stab. You can adduce defense with evidence, will you? I shall not. Do you have anything else to say in connection with the case? I do not know why the case was filed. Why the case was filed?
Impugned judgment comes to you.
Now I take your lordship to the impugned judgment at page 20. Page?
Para 20.
Para 24 of the judgment law. At page 46. At page 46. Next, the point number 9(2) is taken for decision. From the evidence on record, it reveals that none of the prosecution witness had seen the incident. This is very important. None of the prosecution witness had seen the incident. PW1 is the informant of the case. PW1 in his evidence revealed that on 3/9/2009 at about 5 p.m. he was at Bijni. And at that time, his mother Sujola Basumatari, that is PW9, informed him that accused Lena Basumatari stabbed his father with dagger. Immediately he arrived at his house, and before his arrival, his father was brought to Swagat Hospital by 108 ambulance. And thereafter he got information that his father died. Thereafter he lost the FIR. From the evidence of PW2, it reveals that he heard that the quarrel was taken place between the accused Lena Basumatari and this is Ganesh Basumatari, and accused Lena stabbed Ganesh with a knife. PW3 in his evidence also stated that son of Ganesh informed him that accused Lena killed his father by stabbing with dagger. PW4 in his evidence also stated that he got information that the accused Lena Basumatari stabbed Ganesh with a dagger, and after getting information, he went to the house of Ganesh and showed the dead body of Ganesh. These PWs are all hearsay. PW6 is the neighbor of the deceased and accused person. PW6 in his deposition has deposed that on the day of occurrence he was at his home, and at about 4 p.m. he heard that accused Lena Basumatari stabbed Ganesh with dagger. He immediately went to the house of Ganesh and saw Ganesh was lying in injured condition, and he saw cut injuries on the chest of Ganesh and blood was oozing from the injuries. He asked Ganesh about the incident, and he told them that accused Lena caused his injury by stabbing with a knife, and at that time there were gatherings of several people. PW7 in her deposition has deposed that on the day of occurrence at about 3-4 p.m. she was at Lucky Bazar. At the time of Sumitra informed her that accused Lena Basumatari stabbed her son Ganesh by knife. She immediately came to her house and showed Ganesh lying. Ganesh was lying in the courtyard in injured condition, and blood was oozing. And at that time, he was in a position to speak. This is contradictory to the statement of the PW9. He asked Ganesh and told them that accused Lena stabbed him with knife. PW10 in his evidence stated that villagers told him that accused Lena Basumatari alias Gary killed Ganesh Basumatari. PW9 is declared as hostile witness by prosecution. But PW9 was declared as hostile, but nothing has been stated by the Ladakh trial court why she was declared hostile. But because she was the first person to witness the victim in an injured condition. After taking birth, she returned to her house and saw her husband in a serious injured condition nearby her house. And her husband was at that time alive and asked her to give him water. But when she came back with water, her husband was not in a position to speak. This is very important. How the PW6 and 7 has stated that he has told that the appellant has stabbed him, the victim. When he was not in the position to speak, and even one of the PW has stated that when he went to the house of the victim was already dead. That I'll come to. He was brought to Swagat Hospital at Bongaigaon, and in hospital he expired. So from the evidence of PW 1, 2, 3, 4, 6, 7, and 10, it reveals that they heard the accused Lena Kushumatari stabbed. This is Ganesh Kushumatari. Though PW 9 declared as hostile witness, but from her evidence, it reveals that after the incident, deceased was able to speak for some moment, and thereafter he could not able to speak, though he was alive. From the evidence of PW 6 and 7, it reveals that after the incident, they went to the place of occurrence and they found the deceased in injured condition. And on being asked by them, the deceased told them that accused Lena Kushumatari stabbed him with knife. So it appears that this is before his death, lastly speak with PW 6 and 7 as to his cause of injury, which resulted to his death. So this version can be used as oral dying declaration of the deceased Ganesh Kushumatari. Before we take consideration of the said oral dying declaration, we should go through the provisions of Section 32 of the Evidence Act. Section 32 of the Evidence Act. PW 6 is the neighbor and PW 7 is the mother of the victim. She is a interested witness of it. Now I'll take your lordship to my written argument is that I've referred some judgments, lordship, at page 8, lordship. Para 16. It's the following. Page 9, lordship, that the decision rendered by the Honorable Apex Court. 7th line from the top, lordship. The Honorable Apex Court, lordship got it. The Honorable Apex Court has repeatedly laid down the settled principle to be borne in mind while analyzing and accepting dying declaration. This is judgment in the Uttar Pradesh versus State of Uttar Pradesh versus Birpal and under reported in 2022 4 SSC 741. As per the said settled principle laid down by the Honorable Supreme Court, the so-called dying declaration before the PW 6 and 7 cannot be accepted as dying declaration, and therefore the conviction of the appellant solely on the basis of such dying declaration is not sustainable in law, and therefore the impugned conviction and sentence of the appellant is liable to be interfered with and is liable to be set aside and quashed. As such, the benefit of doubt goes in favor of the accused appellant. Accordingly, it is a false and it is a fit case for acquittal of the appellant accused person. I'm placing that judgment. Unta paragraph? Unta paragraph? Page 9, paragraph 17 of my written argument. The so-called oral dying declaration has to be withstand the test and scrutiny of the trial court. And as per the guidelines, principles laid down by the Honorable Supreme Court, which the learned trial court has miserably failed to do so, when there are serious contradictions between the evidences of PW 6, 7, and 9. There was also contradiction as to where the victim was found to be injured condition amongst the other contradictions. Now, paragraph 18, Lordship. In this case, Lordship, this is the judgment passed, one of the judgment. This is leading case, Lordship. Dying declaration can be the sole basis of conviction if the same is found to have been recorded in accordance with law and appears to be truthful and voluntary. 2021 6 SSC, 2013 Jaima versus and another versus State of Karnataka. Also highlighted in paragraph 32 of the judgment that dated 21/12/22, passed by this honorable court, where the honorable court in criminal appeal 46 of the 2021 in Balakram Tupra reported in 1997 or 75 3 SSC 2010. The honorable Supreme Court has cautioned that it is not prudent to base the conviction on the dying declaration made to the investigating officer. Herein, it has been alleged to have been made before PW 6 and 7, more so PW 7 being the mother of the victim, as such the conviction of the appellant ought not to have been made on the basis of their evidences, which is vested interest in witnesses. The learned trial court has not treated with caution while analyzing and accepting the evidence of PW 6 and 7 as to so-called dying declaration. As such, the benefit of doubt goes in favor of the accused appellant. Accordingly, it is a peak case for acquittal of the appellant accused person. Now, Lordship, these are the two judgments, Lordship, passed by this honorable court. Paragraph 32, I am relying on. Well, my lord, Justice Malasinamdu was one of the. Paragraph 32, Lordship. Paragraph 32. Law is well settled that dying declaration can be the sole basis of conviction if the same is found to have been recorded in accordance with law and appears to be truthful and voluntary. In the case of so-and-so, reported in 2021 6 SSC 213, it has been held that recording of dying declaration in presence of judicial or executive magistrate was not compulsory. It is only a rule of prudence, and if permitted by the facts and circumstances of the case, it should preferably be recorded by a judicial or executive magistrate so as to master additional strength to the prosecution case. On the evidentiary value of dying declaration, the Supreme Court, after considering a number of previous decisions on the issue, had further observed that when the dying declaration has been recorded in accordance with law and it gives a cogent and pulsively explanation on the occurrence, the court can rely upon as to the solitary piece of evidence to convict the accused. Now, Lordship, at paragraph 33. As noted herein above, the dying declaration in this case was recorded by IO PW 13. From a careful examination of the dying declaration in the light of evidence brought on record, the following facts have been observed. 33.1. The dying declaration was recorded by IO during the course of investigation without obtaining any certificate from the doctor as regards the mental and physical state of the victim. The same would bear special significance since it has come out from the medical evidence that the victim had suffered severe burn injuries on various parts of the body, including her face, stomach, and the chest. The dying declaration of the victim was recorded 4 or 5 days after the incident when she was undergoing treatment in hospital. During that period, in all likelihood, the victim was under the influence of various drugs, including painkillers. She died with in 2 days thereafter due to schizophrenia. Under the circumstances, it is doubtful if the victim was actually in a proper physical and mental condition to speak. Here, the PW7 is the mother of the victim, Lordship. She is an interested witness. So PW9 has stated that earlier he could be able to speak and asked for a glass of water. Thereafter, when she came with the glass of water, he could not able to speak. And she was declared as hostile, being the first person to witness the victim, Lord. She was declared hostile, and why she was declared hostile, the court below has trial court has not stated any reason why she was declared hostile. And more particularly, the Sumitra and Samram Goswami, those who have informed the PW6 and PW7 that Sumitra, they were not examined. If they would have been examined, the prosecution side would have been in a better position. So there are lapses in the prosecution side, Lordship. Therefore, my respectful submission is that Lordship may accuse the appellant from the charges of under section 309. Now, Lordship, paragraph 35 of the judgment. In Dilip Singh and another Supra, the Supreme Court has observed that although dying declaration recorded by the investigating officer is admissible, but better and more reliable method of recording dying declarations should be taken recourse to, and the one recorded by the police officer may be relied upon if there was no time facility available to the prosecution for adopting better method. In the present case, although there was sufficient time and opportunity to get the dying declaration recorded through a magistrate, the same has not been done, thereby raising a serious doubt on the credibility of Exhibit 9. So here also, Lordship, the PW7 is the mother of the victim, Lordship, and PW6 is an enemy of that appellant. Therefore, both the statements, deposition of PW6 and 7 cannot be taken into consideration. Therefore, Lordship, the trial court has not treated with caution while analyzing and accepting the evidence of PW6 and 7. And so, as to so-called dying declaration. As such, the benefit of doubt goes in favor of the appellant, Lord. Another, I am relying, Lordship, 2007 9th SSC 151. In paragraph 10, Lordship, of the judgment, Mohanlal versus State of Haryana. Paragraph 10, I am relying. Though a Lordship got it, paragraph 10. Though a dying declaration is entitled to get weighted, it is worthwhile to note that the accused has no power of cross-examination. Such a power is essential for eliciting the truth as an obligation of oath could be. This is the reason the court also insists that the dying declaration should be of such nature as to inspire full confidence of the court in its correctness. The court has to be on guard that the statement of the deceased was not as a result of either tutoring or prompting or a product of imagination. The court must be further, here it is a imagination, Lord. It is be further satisfied that the deceased was in a fit state of mind after a clear opportunity to observe and identify the assailant. Once the court is satisfied that the declaration was true and voluntary, undoubtedly it can be based its conviction without any further corroboration. It cannot be laid down as an absolute rule of law that the dying declaration cannot form a sole basis of conviction unless it is corroborated. The rule requiring corroboration is merely a rule of prudence. The court has laid down several judgments. The principles governing dying declaration, which could be summed up as under, is indicated. Now, this is the guidelines law. The law laid down by the Honorable Apex Court. There is neither rule of law nor of prudence that dying declaration cannot be acted upon without corroboration. If the court is satisfied that the dying declaration is true and voluntary, it can be based conviction and on it without corroboration. This court has to scrutinize the dying declaration carefully and must ensure that the declaration is not the result of tutoring, prompting, or imagination. The deceased has had an opportunity to observe and identify the assailant and was in a fit state to make the declaration. Where the dying declaration is suspicious, it should not be acted upon without corroborative evidence. Here is also this the dying declaration, so-called dying declaration is a suspicion. Suspicion. Where the five lordship, where the deceased was unconscious and could never make any dying declaration, the evidence with regard to it is to be rejected. This is very important, Lord.
3, 4, 5.
So he was unconscious. He was not in the state of mind to speak even, as per the PW 9. And the FIR also told that he was unconscious. A dying declaration which suffers from infirmity cannot form the basis of conviction. Merely because a dying declaration does not contain the details as to the occurrence, it is not to be rejected. I'm relying on this 4 and 5, 6, Lordship, where the deceased was unconscious. He was unconscious. The FIR itself stated he was unconscious. So the section 32 of the Evidence Act that will come, Lordship, in the month of May. So Lala Trial Court has miserably failed and stated that the section 32 will come into play. Section 32 of the Evidence Act cannot come into play because of material contradictions in the PWs. And PW 6 and 7 cannot be, their statement cannot be relied upon, Lord. So therefore, my respectful submission is that benefit doubt goes on favor of the appellant. So he may be acquitted from the charges. No. Easy, yeah.
DHC had no problem.
Easy.
DRC had no arrived in 1922.
Now I'm relying on the head note, Lordship, of B. Head note B. Evidence Act 1872. Section 32(1), dying declaration, multiple dying declarations, reliance upon principle for summarized dying declarations supporting defense case, reliance on. Court has to examine a dying declaration scrupulously with a microscopic eye to find out whether it was voluntary, truthful, made in a conscious state of mind. Court must remain alive to all the attendant circumstances at the time when dying declaration comes into being. In case of more than one dying declaration, in strict condition, those dying declarations are extremely important. It cannot be that a dying declaration which supports prosecution alone can be accepted. Court below are fully entitled to act on dying declarations and make them the basis of conviction. While dying declaration pass all the above tests, each criminal trial is an individual aspect. It may differ from other trials in some or other respect, and therefore a mechanical approach to law of dying declaration has to be shunned. This is very important. Now, see, Lordship, criminal trial proof. benefit of doubt, prosecution has to be proved the guilt of accused beyond all reasonable doubt. If two views are possible on evidence adduced in case, one pointing to guilt of accused and other towards his innocence, the view which is favorable to accused should be adopted. Now I am taking your lordship to paragraph
Para 18,
18, 19, and
2021.
2021. Paragraph 18, Lord.
Para?
Para 18. 18, 19, 20, and 21. I feel like. 17 also, Lordship, for a moment. Lordship, good. 17, Lordship. A number of times, the relatives influence, this is important, relative influence the investigating agency and bring about a dying declaration. Here also is the same, Lordship. The dying declaration recorded by the investigating agency have to be very scrupulously examined, and the court must remain alive to all the attendant circumstances at the time when the dying declaration comes into being. In case of more than one dying declaration, the in strict conditions in those dying declarations are extremely important. It cannot be that a dying declaration which supports the prosecution alone can be accepted while the other innocent dying declaration have to be rejected. Such a trend will be extremely dangerous. However, the courts below are fully entitled to act on the dying declarations and make them the basis of conviction where the dying declaration pass all the above tests. Now, para 18, Lordship. The court has to weigh all the attendant circumstances and come to the independent finding where the dying declaration was properly recorded and whether it was voluntarily and truthful. Once the court is convinced that the dying declaration is so recorded, it may be acted upon and can be made a basis of conviction. The court must bear in mind that each criminal trial is an individual aspect. It may differ from the other trial in some or the other respect, and therefore the mechanical approach to the law of dying declaration has to be shunned. This is very important. Here also, Lordship, this was a mechanical. Now, paragraph 19, Lordship. On appreciation of the evidence on record, we are of the considered view that the dying declaration of the deceased recorded by the police officer as well as the executive magistrate are fully corroborated, and there is no inconsistency as regard the rule of the respondent herein in the commission of offense. From a perusal of the statement recorded by so-and-so PSO, the thumb impression of so-and-so, this is which has been identified by her father, Sri so-and-so, as also his cross-examination in which he admitted that the police had already came there and he had identified her thumb impression, and the Mamlatdar had gone inside to record statement. There is no reason as to why so-and-so would give name of her husband in her in-laws in the alleged statement given to her father. A dying declaration is entitled to get weighted. The conviction basing reliance upon the oral dying declaration must made to the father of the deceased is not reliable, and such a declaration can be result of afterthought. Here is also afterthought. This is the reason the court also insists that the dying declaration should be of such nature as to inspire full confidence of the court in its correctness. The court has to be on guard that the statement of the deceased was not as a result of tutoring, prompting, or product of imagination. The court must be further satisfied that the deceased was in a fit state of mind and a clear opportunity to observe and identify the assailant. Once the court is satisfied that the declaration was true and voluntary, undoubtedly it can be based as conviction without any further corroboration. It cannot be laid down as an absolute rule of law that the dying declaration cannot form the sole basis of conviction unless it is corroborated. The rule requiring corroboration is merely a rule of prudence. Paragraph 20, Lordship. The burden of proof in criminal law is beyond all reasonable doubt. The prosecution has to prove the guilt of the accused beyond all reasonable doubt. And it is also the rule of justice in criminal law that if two views are possible on the evidence adduced in the case, one pointing to the guilt of the accused and the other towards his innocence, the view which is favorable to the accused should be adopted. Paragraph 21. After considering the evidence and the judgment of the court below, we are of the opinion that the evidence available on record and the sole evidence of the father of the deceased as compared to the dying declaration do not inspire confidence in the mind of the court of this court to make it the basis of conviction of the respondent accused. Hence, the appeal filed is accordingly dismissed. So here is also the same, Lordship. The interested witness is PW7, who is the mother, and there is a no voluntary, no truthful so-called evidence of the PW6 and 7, Lord,
Cannot be treated.
and cannot be treated as a dying declaration,
Which is the
which is the sole basis of conviction of the appellant. This is my respectful submission. And Lordship, my further respectful submission would be to accuse the appellant and set at liberty, Lord. This is my respectful submission.
Lordship, the prosecution case initiated with the first information report, which is logged by the PW1, who is not admitted with the eyewitness to the occurrence. Whatever he has stated in the FIR, it's from the information he received from his mother, Your Lordship. May I take Your Lordship to the first information report at page 4, Your Lordship? It has been lost by Swarang Basumotari, PW1. And the accused name was Lena Basumotari, the appellant. Humble submission is that around 5 p.m. today, when I was not at my home, my father and the said accused were roaming around together, and thereafter they went to the house of the accused, where an altercation followed by a quarrel took place between them. And the accused suddenly stepped on various parts of my father's person with a dagger and caused him grievous injury. As a result, my father became unconscious and kept lying in the house of the accused. The accused fled away from the place of occurrence after stabbing my father. Later, the villagers, after seeing my father's critical condition, contacted 108 ambulance service and took my father to Swagat Hospital, Bongaigaon. But shortly after arrival at the hospital, my father died. The dead body is still in the hospital. So I pray to you to take necessary action with regard to the incident and applies. Lordship, this information which he lost by way of fire is from the information which is received from his mother, Your Lordship, Suzola Goyari, Your Lordship, PW9, my lord, who has been declared hostile, my lord. PW9 at page 24. Lordship, I know the accused person in the dock. His name is Lena Goyari. The name of his father is Tenta Basumotari. The informant Swarang is my son. The occurrence took place in 2009 on 3rd September. On the day of occurrence at about 4:05 p.m., I went to nearby river to take bath. While I came back after taking boat, I saw my husband in a serious condition nearby my house. He was blood-bathed. I did not find anyone near the place of occurrence. When I came near the body of my husband, he was still alive and asked me to give him water. But when I came back with water, my husband was not in a position to speak. I asked my husband about the SLN, but he could not state. When he was taken to Swagat Hospital at Bongaigaon, he was alive, but not able to speak. I immediately on arrival at the hospital, he expired. Police went to the hospital and did the inquest of the body and forwarded the same for postmortem examination. My son lodged the FIR. Police recorded my statement. The witness has been declared hostile and she is allowed to cross-examine by the prosecution. It is not a fact that I stated to police that I saw accused Lena Bosumotari nearby my injured husband and he was armed with a dagger. It is also not a fact that on my arrival, the said accused person fled away. It is further not fact that I stated to police that on my queries, my husband told me that accused Lena Bosumotari had caused him hurt with a dagger. By defense, it takes 10 to 15 minutes on foot from my house to the river. When I was taking bath, a few young boys told me that a quarrel had been picked up by someone. They did not inform me with whom the quarrel was going on. I immediately rushed to my house. After coming back, I saw my husband in a pool of blood. I did not see anyone nearby. After my coming back, the other villagers too came to our house. Immediately, my husband was taken to Swagat Hospital by 108 ambulance. On arrival at the hospital, he was declared dead. Police went there, but I cannot remember when and how many days after. She was declared hostile, Your Lordship. But I've checked in a 161 statement. She has specifically named the accused person. She did not saw the accused person stabbing, but she saw the accused person standing nearby with a weapon in his hand, Your Lordship. And when the accused person saw her, then he fled away from the scene. It's in the 161 statement, Your Lordship. Then his Lordship, the evidence of this hostile witness cannot be brushed aside as the whole, Your Lordship, the threshold. It has to be supported by independent witness. Here I have to rely on one witness, Gogo Bosumotari, PW7, who is the mother of the victim, Your Lordship, PW7, my lord. Before her, there was oral dying declaration, my lord, made by the victim, PW7, page 20. Lordship has found it, my lord. Page 20 of the paperwork. The complainant, Sarang Bosumotari, is my son. I know accused Lena. We are from the same village. The incident took place around 3 years ago. Around 3-4 p.m., I went to Lokhi Bazaar for shopping. While I was in the market, Sumitra informed me that my son Ganesh had been stabbed by accused Lena. Here, Sumitra was not examined, Your Lordship. On getting the information, I immediately came home. I saw Ganesh lying in the courtyard in injured condition. I saw injury in his chest and both hands. Blood was coming out. At that time, Ganesh was in a position to talk. On being asked, Ganesh told us that accused Lena had stabbed him. Ganesh died while he was being taken to hospital. I did not witness any occurrence. It is not a fact that I did not say in my statement to police that Sumitra informed me that Lena has stabbed my son Ganesh with dagger. It is not a fact that the accused Lena did not kill my son Ganesh by stabbing him with a dagger. It is not a fact that Ganesh had died before I reached the place of occurrence. It is not a fact that Ganesh did not tell me that accused Lena had stabbed him with knife. On reaching the place of occurrence, I did not see Lena there. Lordship, here the witness talks about the oral declaration made by the victim before he died, Your Lordship. And in his previous statement before the police, she has stated that part, Your Lordship, that the victim has stated to her about the Lena stabbing her, Your Lordship. Although on evidence it has come, Lordship, there was oral dying declaration made before PW6 also. But I have checked the previous statement, it's not there, Your Lordship. It is not there. Although PW6 in his examination in chief as well as in cross-examination has stated that the victim has stated him about Lena has stabbed, but it's not there in his previous statement. I have marked it, Your Lordship. I can have a look at it, Your Lordship. Then on the basis of the oral dying declaration made before my lord, the mother of the victim, PW7, coupled with the evidence of PW9, who although is a eyewitness to the occurrence, she was declared hostile, but that hostility part she was cross-examined, Your Lordship. Coupled with the leading to discovery, police has discovered the weapon of offense on being laid by the accused person. May I take your lordship to the evidence of IO now, your lordship PW 11. Page 27. On 3/9/2009, I was working as an attached officer at Bizni Police Station. That day, when officer in charge of Bizni Police Station received a written azahar from Charang Basumotari, he registered Bizni PS case number so and entrusted me with the charge of investigation. On 4/9/2009, I went to Swagat Hospital, Bongaigaon. The dead body was there. I held inquest on the dead body in the hospital itself and sent the dead body to RNB Civil Hospital, Kokrajhar for postmortem examination. I obtained signature of the witnesses in the inquest report in the hospital itself. Thereafter, I went to visit the place of occurrence. I prepared a sketch map. Here also sketch map was not exhibited, so your lordship will not rely on that. But there's a sketch map, which I found it in the case diary. I prepared a sketch map after visiting the place of occurrence and examined the witnesses. On 7/9/2009, I arrested the accused Lena Gayari, alias Basumotari, after interrogating him. When he was interrogated, he said that he would show the dagger with which he had committed the incident. Your lordship will kindly note that part. The accused person informed the police that he can show the place where he has the weapon was hidden. Thereafter, I went to the house of Thega Narjari along with him, the accused, and as shown by Lena Goyari, I seized a dagger from Thega's Narjari's house in presence of witnesses. I seized a dagger from Thega's house. Thereafter, I sent the accused to the court. I collected the postmortem report. After completion of investigation, I submitted charge sheet. That in cross. Around 9:45 p.m. on 3/9/2009, I was entrusted with the charge of investigation. I reached Swagat Hospital at around 9:45 on 4/9/2009, and there I made the accused village head Gajen Basumotari, Bolen Boro, Moneswa Basumotari, and Saboram Basumotari. I took their signature on the inquest report as witnesses. The inquest report was prepared in their presence. At 1 p.m., I sent the dead body to RNB Civil Hospital for postmortem examination. Around 3:15 p.m., I went to the place of occurrence. A section of 2nd APTA battalion went with him. Suzola Gawari, the wife of the deceased, showed me the place of occurrence. I recorded the statement of witnesses at the place of occurrence and in the hospital. I recorded the statement of Suzola Gawari, Bogo Basumotari, and Khogen Basumotari at the place of occurrence. I prepared a sketch map at the place of occurrence itself. On the north of the place of occurrence, there is Garden of Betelnut and other trees. Village road is on the south. Gagaram Goyari's house is on the east and Bhavani Basumotari's house is on the west. The accused was apprehended by the villagers on 6/9/09 and handed over to the police station. I was on law and order duty that day. The distance between the place of occurrence and the place from where the dagger was seized is about 5-6 kilometers. At the time of going to recover the dagger, I took Thekolo with me as witness. There was no blood stain on the dagger that I seized. I did not take the fingerprint of the accused and of the ones of the dagger. I do not remember whether I gave a copy of the scissor list to the owner of the house or not. It is not a fact that the seized dagger is not one related to the incident and the dagger belonged to owner of the house. Here, your lordship, Thega Basumotari, from whose house the weapon was lordship recovered, he was also examined as PW5. May I take your lordship to the evidence of PW5 now? Page 16. Has your lordship got it?
Yes.
Accused Lena Basumotari is my nephew. Complainant Sarang Basumotari is my Halpoti. Ganesh Basumotari, the father of the accused, had died around 3 years. When police came to our village, I came to know that Ganesh Basumotari had died. Police took me to the residence of the accused. Police seized one dagger from my house. I put my signature on the scissor list as a witness, so the scissor list. Today, I have seen the dagger in the court. It was materially exhibited, your lordship. I did not witness the occurrence. I came to know about the occurrence only when the police came. The dagger was found on the road in front of our house. I do not know as to whom the aforesaid dagger belongs. I do not know what is written on the scissor list. Lordship, one aspect your Lordship will kindly note. On being shown by the accused person, the police went to the residence of PW5, wherein the weapon was hidden, your Lordship. It was seized. So that place where the weapon of offense is hidden, it was absolutely within the knowledge of the accused appellant, your Lordship. Others won't have known, my lord. He has led the police to that place, your Lordship. That aspect, your Lordship will kindly note, my lord. This is not a case that the weapon was found at his place or it was found somewhere else. It was found on the basis of the information given by the accused person. That too in the residence of Thoga Bosumotari, my lord. And Thoga Bosumotari did not deny that aspect, your Lordship. That the police came on being informed by the accused person and the weapon was seized, your Lordship. And Lordship, although the doctor was not examined as a witness, postmortem report was exhibited, your Lordship, at page 69. Lordship, wounds, my lord, position and character at page 70. There is a large bone deep cut injury, arm right frontoparietal region of approximate 10 into 3 cm size with edge of underlying bone. There is muscle deep cut injury in approximately so and so, right eyebrow. There is one deep cut injury approximately so and so, right shoulder region. There is large split open cut injury so and so extending from right inframedullary area to right costal margin. There is large 10 into 3 cm size zone, arm supra-umbilical region, perforating C expulsion of omentum and bandage. There are blood clots on both nostrils and mouth. Then Lordship, the opinion of the doctor, page 74. In my opinion, the cause of death is due to massive shock and hemorrhage due to right hemothorax and lung injury and hemoperitoneum and bonal injury, along with C, head injury sustained due to homicidal assault and are antemortem in nature. So, Lordship, the injury coupled with the weapon of offense used when dagger, your Lordship, can be said, your Lordship. May I check the head part, your Lordship, if there was other injuries? There was, Lordship, brain and spinal cord. There is intracerebral hematoma, arm right parietal region. Is there, your Lordship? It might be due to because of fight. It might be injury might have caused. So now your Lordship will decide on the basis of the oral dying declaration made before Gogo Bosumotari PW7, and on the basis of the statement, although she was declared hostile, your Lordship, PW9, coupled with, my lord, there was leading to discovery. If your Lordship's holds, these are sufficient material to hold the conviction against the accused person, then your Lordship will uphold the conviction. I'll leave it to your Lordship, my lord. Apart from these evidence, I did not find any other evidence on record, my lord, so as to substantiate the guilt against the accused person. Other witnesses are just hearsay witnesses, my lord, and some are Lordship, Caesar witnesses. Lordship, may I refer certain judgments of this Honorable Supreme Court, your Lordship. I'll give just the citations, Your Lordship. I've given the list of books. 2013 to SCC 81, para 11 to 21,
To SCC,
to SCC 81, Your Lordship.
Hmm.
It's regarding oral dying declaration, admissibility of the oral dying declaration,
para
para 11 to 21. Lordship, should I read? Because Your Lordship is having single bench also. I'll be just referring, my lord. And then thereafter, next judgment, Your Lordship, 2011. To SCC 36. Para 18 to 31.
2011.
To SCC 36. Himanshu L. Chintu versus State of NCT of Delhi. It's regarding hostile, evidentiary value of hostile witness, my lord. Para 18 to 31. Then one more evidence on hostile witness, Your Lordship. 2014, 13 SCC 90. It's regarding separating shape from the grain, Your Lordship. Para 20 to 27, may I refer, Your Lordship?
Para 20.
20 to 27. And regarding lapses in the investigation, because the IO has not stated that those witnesses have not stated before him and all, those contradiction part is not there. Whether it is fatal or not, Your Lordship, that defect in the investigation process, whether any defect will, whether a accused person will get the benefit out of that. Defect in the investigation, my lord, then 2007, 13 SCC 31. Para 18. Ramappa, Halappa, Pujar and others versus State of Karnataka. Para 18. Then one more judgment on contradiction, how it should be proved, Your Lordship. Two 2015, 9 SCC 588, VK Mishra and another versus State of Uttarakhand and another. Para 14 to 20, my lord. And yes, 14 to 20. Lordship. So on the basis of materialism record, Your Lordship, it finds Your Lordship will appeal the conviction. That is my responsibility.
Only one.
Only one point. Regarding leading to recovery load, there is no disclosure memo prepared by the IO before the alleged recovery in presence of the independent witness.
It may not be material. Other day we have cited their judgment on
And
this
so-
honorable court also. Justice Ansari's judgment.
So far, my learned friend has stated that senior friend has stated that that 161 statement. It is the it cannot come in the way. 161 statement cannot be relied upon. And Lordship, if I take your Lordship to page 14 once for a moment, Lordship. PW 4. Page 14 of the paper. I know Lena Bosumatari and complainant Shaurang Bosumatari present in the dock. The accused father, Ganesh Bosumatari, died on a day around 2 years ago. As regard the occurrence, my mother told me that accused Lena has stabbed Ganesh to death with dagger. I went to the residence of Ganesh and show his dead body, Lord. This PW4 has stated that he saw his dead body. Therefore, the PW6 and 7 statement cannot be relied upon, Lordship. He stated that on oath, he has stated that he has seen the dead body of the victim. And now, Lordship, if you the FIR, Lordship, in the FIR, Lordship, the informant has stated that the accused fled away from the place of occurrence at page 4. The accused fled away. 1, 2, 3, 4, 5, 6th line from the top, Lordship.
Yes.
The accused fled away from the place of occurrence after stabbing my father. Now here the PW11 has stated in his cross that on 4/9/2009, I was there. I met the accused. How come, Lordship? If he has committed the offense, will he go, Lordship? If I question myself, will I go there to see the victim? I'll never go, Lord. My answer will be I will never go. So this is my humble, respectful submission before your Lordship. And Lordship may be pleased to acute the and acknowledge the friend. And there is a contradiction that I have already stated before your Lord. This is my respect. Keep your blood.
Mr. Adar, then responsible for the appellants. Also, Ms. Buyan, and addition to PS. Just one reason. Why are you coming so late?
My lord, because the order was passed on 13, 10 days time was only given.
Subject to your petition being not defective. Yes.
Tomorrow, my lord.
May it please your lordship. My lord, as we get item number 6, lordship, I pray lordship this matter may get taken up at 2, lordship. In the meantime, my affidavit and case lordship may be called for lordship.
No, it's already, there's
After-
a 6 matter.
After that matter, lordship, my matter may be.
I don't know, let's see.
Lordship, I may be allowed to call my additional affidavit in that. And
Actually, I beg to mention 2 motion matters for Friday. Lordship.
What Friday?
Motion matters for Friday,
Monday, we'll have it on Monday.
Monday. Lordship.
Hey, Mr. Lordship, I beg to mention item 9 and 10, my lord. So these matters have come up, my lord, on our prayer, my lord. But today, my lord, my senior Mr. R.P. Sharma has some difficulties, my lord. So, my lord, I prefer some accommodation for the day, man. Can it be on the after tomorrow, man?
Not this week, it will be difficult. I'll take up after a week.
My lord.
On request made on behalf of R.P. Sharma and concept of this list and the draft to 1 week. Same order, item 10.
May it please your lordship.
Yeah.
I pray for listing of a matter for admission on Friday, lordship. The matter is provincialization of service of the petition. Lordship, this is a 2021 matter, and lordship, she has joined the school since 2007, and till now, after endless period of litigation, till now the provincialization has
After
not.
vacation?
Lordship, can it be at least next week?
No. After vacation,
Lordship, then under matter, I pray for orders. Lordship.
same, after vacation.
Much okay.
May I please tell you?
Yeah.
Lordship, it is admission matter for listing. Lordship, if it is possible, Friday or
After
Monday.
vacation, after vacation.
like.
May I please your lordship, I beg to mention for listing lordship, it's a matter regarding compensation appointment. Kindly matter listed on next week.
After vacation.
May I please your lordship, I beg to mention for listing, the matter regarding the termination of service, lordship. Kindly before vacation lottery matter listed.
Is a motion matter, admission matter, or what matter? Is for what? Motion
No lordship, admission lordship,
after vacation?
obliged.
Item 4 and 5 of admit.
May it please your lordship.
Hmm.
I have a submissions on item number 3 and 4, my lord.
Hmm.
I have also challenged the same impugn order in respect of a different college, my lord.
Hmm.
And my lord was pleased to issue notice in the matter. And and direction was given by my lord to list my case also along with this writ petition, my lord.
Hmm.
I may be prejudiced, my lord, if my petition is not taken together, my lord. There is already an order in my case, my lord. WPC number,
Item,
item number 4 and 5 together, but order is with regard to item number 5.
Hmm.
My WPC number, my lord, is WPC number 1162 of 2023. There is already an order, my lord. I am submitting the certified copy of the order, my lord. Same impugn order.
Petition number one.
My lord, may kindly see the last line, my lord.
Hmm. Yes,
This is with regard to item number 5 of today's list. WPC 5610/2022.
yes.
This is in respect of a science college, Jorhat, my lord.
Hmm.
Therefore, my case may also be
Who's appearing on behalf of the other petitioners?
I'm 4 and 5, my
4 and 5. So he wants a different date.
lord.
Okay.
After vacation.
List these matters along with WBC number 5610 of 2022 after the summer vacation.
আমার একেই টাইমে কাটা অনেক বিন্দেশ্বর ব্রহ্ম আমার জবাব থাকে
Seven.
Item number 7, my lord. Other section. Should I inform the other side, my lord, after time? For the time being, my lord.
Why?
I said, okay. Yes.
In this case, my lord, they filed an affidavit in reply to the affidavit filed by the BTC, my lord. We have not received the copy, my lord.
But quick, you pay. Hold on.
Copy has not received.
You are appearing for?
I'm for the private respondent number 5.
Respond number 5.
Right.
Okay, they have not given you copy.
You are supposed to give the copy.
My lord,
That-
reply copy, my lord. You know, opposition copy we have
Reply is
received.
What is reply, my lord?
Yep.
Only deny, nothing else, my lord.
Furnish a copy.
So, my lord, some other day, I have received copy.
Time being, my lord, it can be because my lord, already my lord,
I have gone through it, my lord.
the honorable court, my lord, again, my lord, directed my lord, the learned council for the BTC as well as the state government to file an affidavit, which rule they are following. There is nothing to deny, nothing to admit, my lord, that which rule they are following. And in the compliance of the order of this honorable court, they have filed the affidavit. So for the state government, we have not filed any reply. For the BTC, because they are quoting that the rule is, my lord, which rule, that rule is actually not applicable.
My reply copy.
So this is a technical thing, my lord.
Nothing to be.
Yes.
Secondary also filed, I think, Lordship, earlier occasion,
Technical-
Lordship, Mr. SM sixty has said that he has filed. affidavit.
Secondary to the government of some secondary education. We have finally affidavit.
পয়সা নাই ইহঁতৰ কপি পইচা নাই পইচা
More point.
because so many times when last time also they have taken time.
Yes,
They are not- Yes.
After some time, maximum you can.
who's your senior?
My lord, next week, my lord, it's a here, my lord, he is illegally continuing in the post and they are taking time for health reason, this reason, that reason. It may be, add to my lord, add to my, lord, because it's a 2-page reply only. It has come. It may be taken up at 2 o'clock, my lord.
We'll see. 2 o'clock.
Lordship,
Already there's a lot of cases. fixed.
Lordship, then some other day, Lordship,
Then my lord, taken up, now, my lord, where is the senior?
tomorrow or day after tomorrow.
Legs, time being, my lord, time being, he's done legs, my lord. Let it be time being, I will be waiting, my lord. I'll be waiting because so many times the case is listed, but I'm unable to do because they are filing affidavit. Hearing was also completed, but my lord, because of other things, my lord, twice the hearing was completed, my. But my lord, the item could not be disposed of, and they are taking time each and every time for health grounds.
Okay, after some.
So after some time, my, let it be.
A,
May I please ask your lordship? Here Bhuya is in leg in another court. Kindly pass over the matter for time being.
If it's not available, then what can we do? We'll have to adjourn the matter. Yeah, this court can't keep on waiting for counsels to come. If you're ready to argue the matter, you can argue the matter. Otherwise, I'll adjourn the matter. Counsel is not present, what can I do?
Lordship, my lord, let the matter be fixed after a week, my lord. I just came to know, my lord, affidavit has been filed by the government, my lord, but copy was not served to me, my lord. So I need a copy of my lord, government, my lord.
Okay,
today I will serve a copy to him, my lord.
okay. You have MS?
Why Akhtar?
Why?
Akhtar.
After her to MS, why after council appearing on behalf of Bhuyan, learned council for petition?
Here Bhuya.
Yeah, Bhuyan. Mr.
S. Niyogi, my lord, for secondary education. We have filed the affidavit.
Okay. First, Newkill and standing council, secondary, appeals for secondary education.
K. Barua for respondent number 4.
On request made by Mr. K. Barrow, for the response number 4. List the matter after 1 week.
After vacation,
After vacation, my lord.
let it be after vacation.
After the summer vacation.
Kindly a date may be fixed, my lord, otherwise.
I cannot fix a date after summer vacation.
Obliged.
11 and 12.
My lord, in this case, I need some little accommodation, my lord. Unfortunately, the file is misplaced, my lord, in office.
So the matter had come up 2 days back, my lord. And my lord had fixed it today, 11 and 12. 11 and 12.
11, 12.
2 days back, the matter had come. Mr. Kostab Gogoi had appeared. My lord was pleased to hear. Huh?
Then. He's without his records.
Can't help it, my lord.
Little accommodation, my lord.
I'm only my agreement is man. I came on deputation to Gautam University. I was repatriated. My lord, after the repatriation, I went to join in my parent. This thing, they are not allowing me to join. Why? Because when I came to GU, my lord, I was given a lien for 1 year. But they then, my lord, terminated that lien. I filed the second case before my lord. My lord protected me. And that interim order, my lord, by way of an interim order, that will kept under suspension. So, my lord, within that period itself, I went and my lord applied. Now they say in their affidavit, they filed an affidavit also. They say in their affidavit, my lord, that we have yet to take a decision. This, that, my lord, I'm hanging after my job, I'm hanging, my lord. I'm hanging from, my lord, 26 to 2021, my lord. And I had joined on, my lord, 25/4/22. My lord will accommodate them, no problem. I'll do everything.
Today, Lordship, some difficulties. There,
My lord will accommodate
we have misplaced it, Lordship. We will.
My lord will accommodate them. If required, I'll allow them to make a brief from my lord. My, because the records
When do
I.
you want?
Kali, Orohin? Friday? Huh?
Next week.
Next week. Lordship, next week, my lord.
In the next week, Lordship, we.
Okay, but you can hire in senior counsel.
Second case to implement.
Assisted by MS M Das.
M Das, my lord.
M Das.
Lordship.
Learned counsel for petition. On request made by Gay Gogoi, Learned Standing Counsel Higher Education. List the matter after a week.
Next week, my lord, any date convenient to your lordship. Next week would otherwise also be, my lord, a little bit heavy. Let it be on Monday, my lord, so that we can take a chance, my lord. My lord, in the second case, unfortunately, there is an interim order, my lord. If my lord is graciously pleased, that can be, because the last date, my lord, it could not be extended. If my lord can extend that, otherwise there is an interim order.
Passed in WBC number 3864
3864, no?
of
Yes, your lordship.
2017 shall continue till the next. meeting.
Lordship.
My lord, I am appearing for respondent number 4. Can we name it?
Mr.
D. Rava. D. Rava.
D. Raval, Learned Counsel appears for response number 4.
Next to.
13.
My lord, that pharmacy college matter, wherein, my lord, similarly situated persons or colleges have been given permission for the current year. Now, Pharmacy Council has also granted permission to me. In that, other colleges also deficiencies are there. In spite of that, they have been given for 23-24. I have been prevented. Now, this is the last month, my lord, for admission and all those things. If that is not given to me, my whole infrastructure will go by. Because I have placed, my lord, I have my recollect, I have placed documents before my lord, wherein the colleges, which in the earlier round, my lord, were directed to rectify, they apply that kindly extend our thing. So on that application itself, the government allowed them with the further stipulation that you will have to fill up this. Same thing, my lord, if there is something, I'll also do it, my lord.
Yes.
Lord, can this item be taken after some time? Council Bigo is on leg in court number 12. There's the hearing matter going on there. But
We don't, who's your counsel?
Council Bigo is.
Be going, my lord.
But on behalf of.
Last two occasions also, my lord, because of my friend's absence, the matter could not be taken up.
This is the last month.
Last month, my lord, exam, because June, my lord, course has already started. And this is in Silchar. So, my lord, we still will have some students there, my lord. The other classes, others, my lord, they have started their classes. And my lord, I have given that latest PCI also, my lord. PCI also, my lord, has for this current year also, they have extended my thing, my lord. My lord, it's a communication from the Pharmacy Council of India, 3523, my lord.
Have you applied for your NOC?
But, my lord, I applied for NOC. 19, I applied for NOC. They did not give. I went to Pharmacy Council. By the time COVID was there, Pharmacy Council gave me that clearance. Similarly, my lord, other 4 colleges also same condition. Then, my lord, we got ourselves affiliated with the Sankardev University. Thereafter, my lord, we applied for enhancement of our intake, 60 to 100 in B.Pharma course. That was allowed by the affiliating university. Then we went up before the PCI. PCI also allowed that. Thereafter, my lord, we have been pursuing we have started off the classes. We have been pursuing with the government. The government finally in 2022, my lord, gave us the NOC. Page 44, my lord, would find it, my lord. Then what happened? They gave us for page 44, my lord. With reference to the letters on the subject, sir, I am directed to convey no objection of the government in medical so and so for starting degree diploma in pharmacy course at the following institutes for the admitted batches That is 2021, 21, 22, subject to the condition no further admission for the session 22, 23, and thereafter shall be made by the institute without government permission. This is, my lord, Alama. That is one. Number one is my institute, my lord. Then what had happened was, my lord, after that, when they were not giving us that further, because we were not in a position to take, we came up before this honorable court. When we came up before this honorable court, Mr. Gogoi had brought on record certain materials. My lord, basing on that, I filed an additional affidavit, wherein my lord would find that similar situated persons, colleges, if my lord can have page 60, running page 68, my lord. My lord, my NOC was of 3/6/22. Page 68, my lord would find here NEF College, NEPDS, and my lord, Regional Institute of Pharma Technology. 3 institutions have been given. With same words, my lord. With reference to the letters, I am directed to say that the government of Assam in the education issues no objection certificate for starting degree diploma in pharmacy courses. Admitted batches 2021, 21, 22, subject to the condition that no further admission for the session 22, 23, and thereafter shall be made by the institute without government permission. Similar condition, my lord. And my lord will have clause 2 there. The institution shall fulfill all requirements with regard to physical infrastructure, clinical facility, and teaching facility as laid down by government. Now, these institutions page 70, my lord would find, or my lord may have page 71, my lord, directly. On 22-23, my lord, this year.
Now, are you going to metro? Are we going to wait for?
My lord, it's up to your lordship, my lord. If my lord waits, I have no objection, my lord, because it should be finally.
I think it is best that lordship waits so that.
Let's wait for some time.
My lord will have it at, if not others inconvenient, at 2 o'clock, my lord. If not
No,
others.
I've got many cases fixed.
Oh, lordship, I'll wait, my lord. I'll wait before that.
Lordship, like that.
14, 15, and 16.
May it please, Lordship. Lordship has already heard the matter regarding Lordship selection and appointment to the post of principal of Boroma High Secondary School at Nolbury, where Lordship has gone to the inspector's report and the speaking order passed by the director of PTC. And Lordship will remember the order passed in WPC number 1026, dated 1/6/2023, 22/23/2023.
Which?
Lordship, WPC 1026, order dated 20/03/2023. This was passed by Justice Manoj Chandan Pathak, Lordship.
Date?
20/03/23. It reflects everything. May I read, Lordship? Heard S.K. Goswami, Learned Counsel for the petitioner.
That you can skip.
Lordship. Now, Lordship, the issue relates to the appointment of private respondent number 5 and 6 as a principal of Boroma High Secondary School in the district of Baksa, BTAD. Petitioner, by placing information collected by her through RTI from Sudharani Dhularam Pathak, SDP College of Teachers Education, Tihu, District Nalbari, submitted that no attendance record to be found in the institution during the study period of the respondent number 5 and 6, who was student of B.Ed course studying in the day shift for the session 2014-15. On being inquired, P. Talukdar, Learned Counsel of SDP Teachers College, submitted that SDP College of Teachers Education, from where private respondent number 5 and 6, Bharat Chandra Talukdar, was allowed to obtain B.Ed degree since its inception, is a day shift B.Ed college and does not have an evening shift course in it. On perusal of the affidavit in reply filed by the petitioner, it is also seen that Inspector of Schools Baska, District Circle, Mosolpur, on 23/7/2021, submitted a detailed report before the Director of Education, BTC, Kokrajhar, specifying that no such application either from the respondent number 5 and 6 or former principal of said Boroma High Secondary School was received with regard to the special leave of the private respondent 5/6, and the private respondent 5/6 might have been released
on the sole recommendation of the concerned principal, said Boroma Higher Secondary School, which was respondent number 56, is to use to work. Inspector of School, Baska District Circle, Mosolpur, in the said report that Iman also clarified that private respondent number 56, Bharat Chandra Talukdar, was found to be absent on 2 days, that is 29/8/2015 and 14/9/2015, and on casual leave on 7/9/15 and 9/9/15, 11/9/15, 16/9/15 Iman respectively. And he was not deputed to undergo the B.Ed degree for purpose. It is also seen in spite of such specific report of Inspector of School, Baska District School, Mosolpur, Director of Education, BTC, Kokrajhar, passed the impugned speaking order dated 18/9/2021 without considering such details report of Inspector of Schools, Baska District Circle, Mosolpur. Noted above, holding that concerned respondent number 56, Bharat Chandra Talukdar, obtained B.Ed degree legitimately from SDP College of Teachers Education, TU District, Nalbari, by attending the classes in the evening shift and discharging his duties as a postgraduate teacher in Boroma High Secondary School, and considered the B.Ed degree obtained by the said respondent number as a valid degree. It is to be noted that per Rule 13 of Assam Civil Service, Rule 1965, no government servant while government service shall join or attend any educational institution from purpose of preparing himself or shall appear at an examination of a recognized board or university without obtaining previous permission from the appointed authority. Further, Director of Secondary Education is the appointing authority of the subject teacher in provincialized school, and BETD in the Director of ATC issue notice. Now, Lordship, this order, Lordship, already I have pointed out, the Inspector of Schools has already given a report. May I take you to the report? WBC 1026.
Lordship, please, I allotted to Mr. P. Chaudhary, Lordship.
Yes, please.
Study Council P. Chaudhary is allotted to discuss, Lordship.
And he was heard, Lordship. Already he was heard.
I may be allowed to call him, Lordship.
Yeah, you call him.
I already rang him, but he hasn't picked up my phone, Lordship.
He was heard, Lordship. Lordship has heard the matter. Page 22, Lordship. Page 22 is the inspector's report.
Which
Page 22
of
of WBC 1026.
yes.
This is a report given by the Inspector of Schools to the Director of Education, BTC, in regard to the Lordship B.Ed degree obtained by a private respondent in compliance of the order. Details report on WBC number Iman Anupama Division, State of Assam, that was filed by the petitioner selling the B.Ed degree. With reference to the subject cited above, I have the honor to furnish here with the details report along with the necessary document regarding B.Ed degree obtained by Bharat Chandra Talukdar for compliance of the Honorable High Court order that demand passed in the above petition. In connection with the mention that related documents in support of the obtaining B.Ed degree from SDP College of Teachers Education, TU, are seen and verified meticulously, in addition to accepting statement in his presence in person in the office on 15/7/2021 at 1:30. In connection with the application dated 15/7/2014 for permission to study higher education, it may be stated that no record is available receiving such application in the office as now. Copy of enclosed is Annexure 1. However, no forwarding letter from the school authority of such application regarding permission for B.Ed study was received by this office. I also seen that application dated 9/1/15 enclosed in Annexure 2 herewith was applied alone to the principal of Boroma High Secondary School, praying for permission to attend the practice teaching classes of B.Ed course, and was allowed and permitted by the concerned principal. It was not informed to this office. Read the application dated 24/8/2015, presented to the principal of Boroma High Secondary School for special leave for a period of 10 days from 29/8/2015 to 21/9/15 for appearing B.Ed examination and all other related papers. Copy enclosed Annexure 3. It may be stated that no such application either from Bharat Chandra Talukdar or from concerned principal was received in the office. In connection, it may be informed that as per leave rules 1934, Government of Assam government employee shall have to apply through its department or proportional for approval. Seen and verified the specific leave day period as mentioned in the application relatively to the normal teaching activity of Bharat Chandra Talukdar. He stated while accepting the statement on 15/7/2021 in the office, he was on regular both in normal class duties and B.Ed classes at SDP College of Teachers Education, TU. That was admitted into B.Ed college was not informed to this office either. It may be noted that Bharat Chandra Talukdar, as per his attendance register, was absent on 2 days leave on Iman and Iman. He had no casual leave attendance on an Iman and Iman on Iman. And he casual leave days only Iman and Iman respectively. It is said that Bharat Chaludar was not deputed to BEd study through proportional. In view of the above, the higher education may take the appropriate decision. Now, decision is page 23. Page 23 is the decision by the Director of BTC. Peruse the Honorable High Court order dated 12/3/2021, Iman Iman. Hardly respondent number 6, Bharat Chandra Talukdar, subject teacher, Boroma Higher Secondary School, on 17/6/2021 at 11:30 am in the office chamber of the Director of Education, BTC. The petitioner Nupama Devi, principal of Boroma High Secondary School, filed a case before the Honorable High Court, Iman, against BEd degree obtained by Bharat Chandra Talukdar, subject teacher of Boroma High Secondary School. It is found the materials available on the record that Bharat Chandra Talukdar, subject teacher of Boroma High Secondary School in the district of Baska, admitted to BEd training course, SDB College of Teachers Education, TU, in the year 2014-15. With due permission from the principal of Boroma High Secondary School and inspector of schools, Baska. To that effect, they have no objection to study higher education, BEd training course without hampering his regular classes of the school. He attended his practice teaching classes BEd course of the school with due permission from the principal without hampering normal duties, and also appeared in the final examination BEd course 2015 on special casual leave granted by the principal of the school. He passed BEd training course in year 2015 in the first class legitimately with SDB College of Teachers Education, TU, as a result declared on Iman. Further, it is found that office memorandum dated Iman, the person appointed the post of postgraduate teacher, graduate teacher of Provincial High Secondary School, higher school, with relaxation of professional qualification, BEd degree may be obtained, BEd course from BEd College of the State, which have affiliation to Guwahati University, Dibrugarh University, of Assam University in the evening shift, where normal classes of the school are not hampered. No prior permission shall be required. The teachers who desire to obtain BEd degree from the such college may get admission with the intimation to the respective head of the institution and inspector of schools concerned. The competent authority shall grant leave to the enabled teacher to appear in the examination and practice culture. Now, Lordship will kindly consider the inspector's report was not considered at all. On last occasion, Standing Council has said that the inspector's report was not there. Lordship, NCT has already filed affidavit that 80% attendance in a BEd class is necessary. That affidavit is there, Lordship. 80% attendance or 200 working days. Both teachers and the students. And he's a regular teacher of Boroma High Secondary School. And SDB College of Teachers Education College is a day shift college. That is also ascertained by this court from the council representing the SDB College of Teachers Education. So this is admitted position that it's a day shift college and he has no attendance register. He has no attendance in the school because he is a regular teacher of a school and that is a day shift college. So without taking permission from the inspector of schools, he has obtained the BEd degree. And Lordship, the inspector of schools has clearly given the report to the director of BTC. And Lordship, they want to rely. Lordship has already gone through the notification where BEd degree can be obtained in the evening shift. That notification was issued by the office memorandum. Lordship already in the record, 28 July 2014. 28 July 2014 notification.
Yes.
That is, Lordship, there are 6, Lordship. 6. The person appointed in the post of postgraduate teacher, graduate teacher in provincialized higher secondary school, high madrasa with relation to professional qualification of BEd degree as per government notification number Iman may pursue BEd degree from BEd college in the state, have affiliation to Guwahati University, Dibrugarh University, Assam University in the evening shift. Evening shift, Lordship. But it is admittedly the day shift college and he has no attendance at all. He was not deputed for undergo the BEd course. Teachers who desire to BEd degree from college may get admission with intimation to the respective head of that institution and inspector of schools. He has not taken any permission from inspector of schools. Competent authorities shall grant leave to enable teachers to approve the examination and practical classes. There is no leave also, nothing. Now I will take your Lordship to the affidavit filed by the NCT, where it has been specifically stated.
Where's the affidavit?
Lordship, the affidavit will be found at WPC 337 of 2021. This is an analogous case. Page 38, Lordship. NCT's affidavit.
Page 38.
Page 38.
Yes.
Lordship, got it.
Hmm.
This is Lordship affidavit opposition filed by respondent number 4, National Council of Teachers Education. Lordship, got it. Now I'll take a look at the next page, where relevant portion is there, Lordship. Para 4. Your humble deponent beg to state that Regulation 2014, which came into effect on 28/1/2014, namely National Council of Teachers Education Recognition, Norms and Procedure, Regulation 2014, we lay down the norms and standard of B.Ed program, and all B.Ed institutions shall follow the regulation while conducting B.Ed program in their respective institution, namely Clause 2 of Annexure 4, NCT Regulation 2014, provides the requisite working days and duration of as quoted below. Duration. B.Ed program shall be a duration of 2 academic years, which can be completed in a maximum 3 years from the date of admission to the institution. 2. Working days. There shall be at least 200 working days each year, exclusively for a period of examination and admission. B. Institution shall work for a minimum of 36 hours a week, during which physical presence in the institution of all teachers and student teachers is necessary to ensure the availability for advice, guidance, dialogue, and consultation when needed. C. Minimum attendance of student teachers shall be have 80% all classes, all courses working part camp, and 90% for school internship. So, Lordship, the NCT has clarified, Lordship, 80% attendance for B.Ed course is necessary. He is a regular teacher of Boroma Higher Secondary School. He days if he obtained the admission in B.Ed course without attending the class, he has appeared in the B.Ed examination conducted by the Guwahati University by manipulating the record. So his B.Ed degree is not qualified to be appointed as a principal of a school. Earlier occasion, Lordship, petitioner has approached this honorable court. Lordship will find his selection and appointment was set aside by this honorable court, and Lordship will find page 24 of this writ petition, 337 of 2021. Lordship will find the order at page 24 regarding the B.Ed degree of the private respondent.
24.
Page 24. Dated 31/7/2000. Considering the facts, petitioner has challenged the B.Ed degree of the private respondent number 5, Guwahati University, will clarify about same with reference to the pleading of the petition. Now I'll take the relevant judgment at page 26. Page 26. This order dated 6/3/2020, page 28. Lordship got it.
Yes.
Now, Lordship, I'll take your Lordship directly to the page 32.
Why was this writ petition filed?
Challenging his selection and appointment to the post of principal. That is why we have challenged the writ petition. The selection procedure was irregular. That is why we have challenged. Page 32. Accordingly, the appointment of private respondent is set aside. Lordship got it. Respondent authorities are directed to initiate fresh requirement process appointment to the post of principal of Boroma Higher Secondary School by adhering to the procedure prescribed under 2003 rule. Thereafter, Lordship, he has preferred re-appeal before this honorable court. Lordship will find the re-appeal order. Re-appeal also dismissed and affirmed this order of the passed by this honorable court, Lordship.
Page.
Lordship. Lordship will find, may I take your Lordship to the WPC 8277. That was not annexed in this petition, Lordship. 8277 of 2022 connected petition. 8277. WPC 8277. Lordship got it, page 42.
Yes.
Retapil number 64 of 2020. Bharat Chandra Talukdar, the private respondent. Now Lordship will find the relevant portion. Page 55. Page 35.
Which?
Page 55.
Yes.
As such, while upholding the decision of the Honorable Single Judge, already I have shown the judgment, Lordship. Upholding the judgment of the single judge, setting aside the appointment of the appellant as a principal of Boroma Higher Secondary School, we modify the relevant direction of the single judge to the extent that respondent authorities shall initiate fresh recruitment process for appointment of the post of principal of Boroma Higher Secondary School by adhering the procedure prescribed under Rule 2018. Earlier, Lordship, 2002 rule was quoted, but division bench says 2018 rule. Now, Lordship, again, he was selected as a principal of Boroma High Secondary School by the BTC authorities without concealing the inspector's report. And that is why, Lordship, the earlier occasion, the standing counsel appear from Boroma High Secondary BTC has clarified that the order was not placed before the director of BTC. That is why speaking order has been passed. And he has agreed that that should be set aside. That is why, Lordship, we have filed 3 petitions. Originally, we have challenging the speaking order. We have challenged the selection of appointment of Boroma High Secondary School of private respondent. Thereafter, Lordship, the speaking order has been produced before the court. That speaking order has been passed by the BTC authority on the basis he was appointed. That is why subsequently we filed WPC case number 1026. The speaking order has been challenged. So my submission to be Lordship will dispose the 1026 that the speaking order passed by the director of BTC is not in conformity with the notification issued by the government. That is a day shift college. That is not evening shift. We have also obtained the RTA information from the SDP College of Teachers Education. They have given information that there is no attendance of in the college of Bharat Chandra Talukdar in the college, and college is a day shift college. May I place the RTA information also, Lordship? We have received.
What about the other 2 petitions?
Other petition, one is, Lordship, this court has held already. In selection and appointment to the post of principal should be held as per 2018 rules, but they have not followed 2018 rules. That is why I have challenged his selection as well as the mark given to him in the selection process. Not only BA degree, but other marks. But if Lordship will decide the 1026, it will affect everything. Because if BA degree is not there, minimum qualification for post of principal is he must have a BA degree from a recognized university. If BA degree is not entitled, then other petition, Lordship, may not go to the all extent. If BA degree speaking order is set aside by this honorable court, everything will be finished, Lordship. And I may be given liberty if Lordship authorities done anything, I may go for again, Lordship. Because this is a 4th round of litigation. Already 3 petition is pending regarding his selection. On technical, we have to challenge the speaking order. That is why I have to file 1026 subsequently. And BTC authority has already clarified that speaking order has been passed by the director of BTC without taking note of the inspector's report. Lordship already heard the matter. And SDP College of Teachers Education standing counsel is there, Lordship. NCT already filed affidavit, NCT is there. And last occasion, Lordship has not passed the order on the ground that the standing counsel of Guwahati University was not there. That is why Lordship has granted them time till last occasion, Lordship. Thereafter, today, the Lordship has fixed this matter. For
Did they also standing counsel Guwahati University is present?
Please appearing, Lordship. They have no objection.
We have no objection.
What is it?
On the last date, we have clarified that the degree awarded by the university is valid because university given the application. And if the Lordship find that it is not as per the procedure, then we will withdraw it. We have no objection.
The BA degree.
As per Guwahati University Act 1947 specifically prescribed, the authority can withdraw the BA degree if Lordship held. To withdraw the cancelled degree, diploma, certificate, or other distinction granted to be conferred. Section 5 power of university. If Lordship held the BA degree is invalid, considering the facts that he has, without attending the classes, he has obtained a BA degree. And Lordship, without attendance, he is a regular teacher of the school. He has not taken permission from the authority to obtain the BA degree, to undergo. Because Lordship, Assam Civil Services Conduct Rule 1965, Section 13.
Where's that rule?
Section 13 of Assam Service Conduct Rules 1965.
This one. Assam,
Assam Civil Services Conduct Rule 1965. Rule 13.
page.
Lordship, I have this book, Lordship. Rule 13.
1 minute. 1965.
1965. Rule 13. Lordship got it. Rule 13. Prosecution of studies by government servant in educational institution. No government servant while in government service shall join or attend any educational institution for the purpose of preparing himself or shall appear in an examination of a recognized board or university without obtaining previous permission from the appointing authority. Not from principal, Lordship. Appointing authority. Appointing authority is Director of Secondary Education. He has said principal has authorized him. Inspector has categorically given a report that no permission has been given by the inspector of schools. That is the inspector's report. So without obtaining permission, without leave, without attending the class, he has appeared. And that degree is to be applied for giving a post of principal of a school. So we have to challenge the speaking order. If Lordship allowed this 1026, everything will be overlooked. Though Lordship, the marks allotted in the selection process will not be relevant. Will not be relevant. If his initial qualification for entering the service as a principal is not here, he cannot appear in the selection.
So 1026.
1026, Lordship. We have challenged the speaking order.
You have challenged only the speaking order.
Speaking order.
Have
And
you-
other
have you
petitions,
challenged-
treaties, I will give it a list, Lordship.
Have we challenged the degree?
Degree. Be it speaking order.
No, speaking order is challenged.
Lordship. 337, we have challenged the BA degree.
327.
Lordship.
Yes. Who appears?
My lord, I am appear for respondent number 6 in WBC number 337 of 2021 and respondent number 5 for repetition number 1026 and my lord 8277 my lord. My lord, my humble submission, my lord, regarding the degree of B.Ed, my lord. My private respondent took the B.Ed degree with the permission of principal as well as the permission of the inspector of the school, my lord. Fairly, my lord. Now, my lord, my humble submission, since the, my lord, the private respondent, my lord, hold the post of postgraduate teacher is illegal as because, my lord, she was joined in the year 1987 as assistant teacher, my lord. But there is no any provision.
No, are you challenging the? This
But there is no
this
provision,
his
my lord.
petition.
How he promoted to the post of assistant teacher to PGD? I mean, as per
That you
recruitment route
can't,
to
that you can't argue in this, in his writ petition. You have to file a separate. writ
My lord,
petition.
I have
Now,
filed
all you have to say is
My lord.
whether you took permission from the inspector of schools.
my lord. My lord, yeah, page number, my lord.
Which,
Office memorandum, my lord. Kindly see, I have filed one affidavit in opposition, my lord.
writ
In
petition?
WPC number 8277/2022, my lord. Page number, my lord, 31, sorry, 21 to 22, my lord.
Office memorandum, I have already shown, Lordship.
My lord.
Where? Page?
Page number 21 to 22, my lord.
of your affidavit,
my lord, of the affidavit of 8277, my lord.
21 to
Whereby it is fairly stated that
page,
in the
page,
day,
page.
page, my lord, 21, my lord, annexure 4, my lord.
Yes. Did you obtain your B.Ed degree from the day shift or the night?
Day shift, my lord.
Day shift.
And if anybody take the degree in the day shift, my lord, with the permission of the concerning head of the institution, that is principal, as well of the concerning district's head, that is inspector of schools, then he can take the degree of B.Ed, my lord. And in the evening shift, my lord, there is no need to prior permission of the concerning institution, my lord, to take the degree of B.Ed, my lord.
So you took in the day shift.
Day shift, my lord. And that degree is absolutely legitimate, my lord. And in the speaking order is also is fairly stated, my lord, in the first paragraph.
Speaking order says night shift.
Day shift, my lord.
Speaking order says night shift.
But he took the degree in the day shift, my lord.
Day shift.
And
Read
my
this
lord,
memorandum, read this.
5213/2019, that in the writ petition, my lord, that was observation is given that published the advertisement and took the selection, and in person of the merit, my lord,
That
he
is the
should be
defecting, that
elected,
is the
selecting the
defecting. Now-
appointment.
now
And
your
on that,
degrees are the challenge.
on the selection, my
Read
lord,
para 6 of the office memorandum.
para 8
6.
of the affidavit of, and para 6 of the
Office
office
memorandum.
memorandum.
Annexure 4.
And annexure 5 is 33 of the affidavit of which one, my lord.
I'm asking you to read para 6 of
Mal-
annexure
mal-
4. Yes,
May I read, my lord?
yes.
Para 6, my lord, the persons appointed in the post of the postgraduate teacher in provincial higher secondary and high school, high madrasa, with relaxation of professional qualification of B.Ed degree as per government notification number so and so dated 13/9/2012, may pursue B.Ed degree from the B.Ed colleges in the state which have affiliated by the Guwahati University, Dibrugarh University, and Assam University in the evening shift classes where normal classes of the school are not hampered. No prior permission shall be required. The teachers who desire to obtain B.Ed degree from such college may get admission with intimation to the respective head of the institution and the inspector of school. Concerned, the competent authority shall grant leave to enable the teacher to appear in examination, practical classes, etc.
What does it say? How you interpret that?
Inspector, even principal as well as inspector. That they in the private restaurant intimated to
It
the
says for those teachers
my lord.
who have been appointed with relaxation of educational qualification and who wishes to pursue their B.Ed degree may do so from those colleges who have affiliation in the Guwahati University, Assam University, Dibrugarh University,
My lord.
in the night shift. In the night shift classes.
Day shift and evening shift, my lord.
Where's the day shift given here?
Evening.
Where's the day shift? Language is very clear in the night shift. And for those who wants to study in such colleges, no prior permission is required. However, intimation has to be given to principal and the inspector of schools. There's no mention of day shift. Under whose permission did you take your B.Ed degree?
I am reading again, my lord.
No need, not required. Yes, counsel. Any more submissions?
The petitioner took the permission from the concerning authority and took the degree
permission?
legitimately. This is my.
Where's the grant of permission?
Well, kindly,
Where's the grant of permission? Permission. you have to take- you have to take from the appointing authority.
my lord. Annexure 2, my lord, is to pay, type paper and relevant portion is page 13, my lord, of the affidavit in 8277, my lord. And that was permitted and allowed, my lord.
Where? Annexure?
Annexure 2, relevant portion is page 13, my lord. Permitted, my lord. SD eligible 9/1/2015, principal, Boroma SS School, Baksa PAT. And another, my lord, page 14, annexure 2, a prayer for specially for B.Ed examination, my lord. And relevant portion is page 15, my lord. That was allowed, my lord, on 24/2/2015, my lord. And thereafter page annexure 3, page 16, my lord. Prayer for permission to study for higher education, my lord. That was allowed by the inspector of schools, Baksha, in district circle, Musalpur, my lord. And another once a certificate has been issued by the inspector of schools, my lord. Page 17, my lord, annexure 3A, to whom it may concern, my lord, certificate that Mr. Bharat Chandra Talukdar, M.Com B.Ed, had served as the principal of the Burma High Secondary School with effect from 29/5/2019 on being appointed height number so and so dated so and so with the best of his ability till 15 July 2020. Prior to appointment as the principal of the school, he had worked as the PGT in the accountancy since 1998, which he informed, which he performed with sincerity and dedication as a PGT in accountancy.
Your certificate.
My lord, this is certificate issued by the inspector of school, DDC Mostalpur, my lord. And another certificate has been issued by the principal of the school, college, my lord, SDP College of Teachers Education, my lord. This is the certificate that the person
I'm not on the certificate, I'm on the permission.
regarding permission, my lord, only this annexed to and
Who is the appointing authority?
appointing
Director of BTC.
Director of BTC.
Have you taken the permission of director?
No, my lord, inspector of it.
Inspector in the night shift only. They are intimidated.
আপনার office member revealed that my lord, principal as well as the inspector of school.
For
The
night shift,
permission of the
for
school
night
is
shift
required.
classes. For night shift, not day shift. Who is Chaudhary Bora?
Lordship, actually, P. Sudhuri was looking after, he is on Lexing Court number 7, Lordship. Lordship, record is with him, Lordship. With P. Sudhuri. After some time, Lord.
Lordship has already heard the matter and gone to the record also.
Let's wait for some time. Because I have some questions to ask Chaudhary.
As soon as he will be complete, he will come to join.
Now how do we proceed? Not a single case is being disposed today. Wait for something.
Keep them.
17 and 18.
Matter after some time. Why? Why all cases after some time, after some time? Huh?
In fact, here, two read petitions. One is Right. Yes, come. So. Acha. My lord, these two read petitions by the same read petitioner. One, that is WPC 4111. This is probably item 18. This relates to the advertisement issued for filling up the post of principal of the University Law College, which is a constituent college. There, advertisement was issued which showed the eligibility qualification which describes me. I am a assistant professor working there for more than 22 years in the University Law College as a regular teacher and senior most teacher there. So I challenge this that it didn't conform to the requirement as per the rules of their own as well as the UGC. So this cannot sustain. This honorable court passed an interim order saying that meanwhile I can also apply. My application should be accepted. They may process, but no final decision should be made out. That was the position, and there this first petition is pending. Now what happened? Then the post fell vacant, post of principal. Advertisement was issued, applications are taken, including mine. But process is lying there. Now that post principal, of which I am a teacher, should be filled up as in charge principal on in charge basis. There, the authority, without considering the case of this petitioner, appointed other persons. Initially, the charge was given to the secretary of the university classes. Then this was given to the head of the department of LLM of the university postgraduate class. Then that person went on retirement. Again, it was taken by the secretary. Then my representation was there that I am also there. Earlier, you used to give me charge as and when the principal was out of the office continuously for 11, 12 years. As and when occasion arises, I was given the charge. I am the senior most. You have not considered my case. Then ultimately, when I approached this honorable court, then again they changed that order and again given the charge to the respondent number 5. That's 6, yeah. In the second report, so 1551. Respondent number 4, who is holding the post of the head of the department of the LLM. Master of Law. There. So I have assailed that order also, that the non-consideration of the petitioner as well as the appointment of the respondent number 4, allowing her to hold the charge is detrimental to the interest of the college, and therefore an appropriate direction should be issued that the authority should consider my case as well as take a call as to why a person who is competent, who is otherwise eligible to hold the charge of the post of principal of the college while working in the same college is not being considered for giving the charge. That is the issue involved here. The first writ petition, that is 4111, that relates to the advertisement of the principal post. Second one relates to the filling up the post temporarily on ad hoc basis, that is in charge basis, until the regular appointment is made. I am approaching the approach of the university is such that they are not proceeding further with the advertisement, that to take it to a logical end. They would have accepted my application and sitting tight. Meanwhile, they are considering to give it to some person. The secretary of university classes himself holding the charge, taking it to himself, then giving to another person. When he goes, again he takes it to himself. Again, it gives to the another person who is in the LLM department. Now, whether that is a fair exercise of power, whether that is just and beneficial to the interest of this institution as such, and it amounts to denial of an opportunity which is otherwise due to the petitioner also. In case of the first one, writ petition, the university authority has not filed any counter. They have not come up with any counter. In the second writ petition, that is the in charge principal, there the private respondent has filed an affidavit. She has filed an affidavit, and that I have also filed a reply. So far, respondent number 4 in the writ petition 1551, madam, is concerned. No, oh, yes. 1551 is concerned, that is the in charge principal. In my response submission, she is holding the post because she has been asked to hold the post. And she is to that extent a formal party, because if this honorable court ultimately finds that this arrangement ought not to have been there, my case ought to have been considered, then in that case she will have to make way for me. She is to that extent is a formal party here. Otherwise, I have no grievance, because she is holding a substantive post of the department, LLM department, and presently she is the head of the department of the University Department of Law. Department of Law. Therefore, the first one only on the basis of law, whether the post of the advertisement issued was in conformity with the UGC rules, and it contains the eligibility conditions of the candidates in accordance with the rules which prescribes the qualification. That is basically only on the question of law. And the second is also, the question is, who should be given the charge? As I understand, question may be raised that if I am not qualified, this is the only, my lord, what I find the hurdle. If the contention of the respondent is, though they have not come up with, university has not come up with any specific plea, that I have not been given the charge, they may think that I am not eligible to hold the post because I do not have the requisite qualification to hold the post. They might say that. Then my answer would be that under the prescribed rules of the university, I mean University Grants Commission, I am entitled to, and prima facie being satisfied, this honorable court has already directed that his application should be taken and should be considered. You may not declare the result, but it should be considered. So this itself shows that I am prima facie eligible for the post of principal of the University Law College. And to hold the post, even they have not allowed me, and this is sequel to the first writ petition. They have not taken it in good grace that I have come against the university, my employer, and have filed the first writ petition asking that no, your advertisement is wrong. That was not taken into in good grace. To my understanding, that is the only reason why they have prevented me from acting as the in charge principal. When the charge has been given to one of the associate professors or assistant professor, assistant professor, this is response number 4. She is also an assistant professor working in the department of
You are associate.
sorry. I am also assistant professor. She is also an assistant professor. Response number 4 is also an assistant professor. She is working in the department, LLM. I am also an assistant professor working for 22 years and on. And I am the senior most teacher of the college, the University Law College. I am directly in the
Respondent number 4 is associate professor. The petitioner is assistant professor.
associate professor. It has not been shown here. It shows assistant professor. That is why I am saying from this document, which is there in the system. And in affidavit also, it has not been disclosed whether she is an assistant professor or associate professor. So, it has not been disclosed, but the system disclosed that she is an assistant professor. Whatever it might be, well, associate professor, I am also entitled to the post of associate professor had the authority been acted upon the approval given by the IQAC. My case has already been cleared long back for upgradation to the post of associate professor, but the university is sitting tight. They have not convened the interview. They have not given me that rank till date. This is the injustice done to me. At any rate, At any rate, a person who has been given charge of the college has no connection whatsoever with the college directly. She has her own substantive post and duty to discharge in the department. Cannot pay attention, or only half-hearted attention can be paid. Whether it would be for the interest of the institution as such, the law college. Merely giving charge is not the sole motto, that just to hold the charge. It must serve the purpose for which the charge is given. A person must be able to render service there. Therefore, the respondent number 4, she is holding the substantive post as a lecturer, as an assistant professor or associate professor, if it is so. She has not disclosed it, whatever it may be. There is department, she is working there. I have no grievance to that so far. But should it, or was it fair on the part of the authority to deny me and give the charge to such a person and keep on changing? LEC, but LEC it was held by the registrar himself. Then, when I raised objections that, well, why not me? Then it was given to the then head of the department of the LLM. Then she goes, again he has taken to himself. Then I approached this honorable court that time. Then he again changed it and given to respondent number 4. Yes. Therefore,
So
my
are we hearing this, both the writ petitions?
Lordship may have both this together, because firstly, Lordship will have to see, because I requested this honorable court to put both the cases together. In the first writ petition relates to the advertisement and qualification.
But, Guwahati, have you filed your counter?
My lord, in the first case, we have not filed any counter, but in the second case,
Second case is something else.
my lord,
That is with regard to in charge.
in
In
charge.
charge.
In charge.
But in the first case, we have.
First
not
case
filed
is with regard to the advertisement, the qualification.
qualification.
Yes,
As
So
per,
there in affidavit is required, isn't it?
my lord,
they have not come up.
my lord, I'll pray for some time to file that affidavit. Almost ready, my lord.
My lord, they may take time. They have got enough time. University may go for praying for further time. But only thing is, I am retiring.
When?
I am retiring in the next year, January, February, that time, January last,
February.
February.
last.
February. I am retiring in February. Term is running out. My everything will be infructuous and my long service. I have to face humiliation. Lordship will kindly see the situation. Kindly see all these documents I have annexed for last 11 years, for even single day, 2 days, 3 days, all the time, it was the charge was given to me. They said that it was not in the usual course. Sometimes occasion arises that for you were given charge. But now, someone will have to act regularly as officiating principal. Therefore, we have not given it to you. We have given it to another person. That cannot be a good ground.
Furkan, when can you file it?
My lord,
Ministry is retiring.
this 10-12 days, my lord.
Then immediately after the summer vacation, we can hear this.
Immediately after.
It was filed in 2022. 2022, it was filed.
Then we'll give him some time to file his counter.
Well, the only thing is my worry is interim order. For interim order, it was fixed in the second case, in charge. Because that time notice was issued to the private respondent 4. And interim order might affect immediately. Therefore, for fairness, notice was issued to respondent number 4. And respondent number 4 has appeared and filed an affidavit. So, may I now pray that since the matter is going to take some more time, at least interim order should be considered.
No, we'll dispose it on the next returnable date.
Well, that is
That will be
always,
better.
that is why I expected that that would be done today itself. But since they have not come up with the reply,
No, Furkan, can you positively file by 2 weeks?
My lord,
If
I'll-
that is the thing, we can immediately fix a date
Because-
after the summer vacation.
my lord, it needs at least so that my petition doesn't get infracted.
Yes.
Lordship may fix it accordingly.
But KK Manda, the senior counsel, assisted by Mr. K. Sinha, the counsel for the petition. Mr. PG Furkan and the standing counsel body in
That will
next
be
for 2 weeks time.
Huh?
To file counter affidavit in WBC number
4111 of
4111 of
2022.
MS.
And for respondent number 4.
Your MS Fornally. Also, then appears for respond number 4. Stop. List the matter. You want a date fixed?
Yes, my lord, so that my lord, let after 2 weeks, a date be fixed for filing.
If you want to file the agenda, you can file, we'll have it on 25th July.
My lord,
Lordship,
Tuesday.
25th of July.
25th of, my lord, July, 25th of July for disposal.
Yes,
Lordship will say meanwhile, they may file within 2 weeks,
I've said within
Within 2
2
weeks.
Yes.
so that we can, if necessary, we can also file rejoinder.
25th.
Lordship may record, my lord, disposal,
And
because
attempt shall be
urgency is
made
there.
to dispose of this petition on the next written.
problem.
And my lord, one thing, my lord, that the second case, we have filed affidavit in opposition, some pertinent question of law have cropped up, my lord, but no response has been filed as yet. So, my lord,
That is up to them.
my lord,
We'll see it, my lord, because the question of law can be answered without facts only to be replied. We'll see to it.
obliged.
Dismissed.
Item 1, 2, and 3, admission, part of it.
Keep it for some time, I think I will do some mistakes. Yes.
My lord, at the very beginning, I'll just point out before lordship that I will only rebut.
Yeah.
Nothing to argue new. So no one will get a chance after rebutting, my lord. Normally now these that after rebuttal, again argument, again my argument, that's rebuttal. If I say something new, then a chance is given. Nothing I will go beyond what my learned friend has said, reply. So basically I'll start with number 1. My lord, my learned friend has first stated 3 points he has formulated. 3 points formulated. First, he said there is no violation of AICT regulation. Your lordship will kindly see the note. There is no violation of the AICT regulation as experience is required only in recruitment entry level 11. Post of lecturer, not in entry level 9 and 10. That's the first point. And your lordship will recollect. Your lordship will recollect that my learned friend has shown first the advertisement. The advertisement followed by the qualification. Qualification. Now, my lord, we don't dispute about the qualification. Qualification is a prerogative of the authority concerned. And it is only the qualification which is laid down is the AICT which lays down the qualification, which is adopted by the state government. That's what the AICT notification says. We are not disputing about the qualification. Your lordship will, again, it has been asked from where you bought the syllabus. That's what your answer is. That's what your lordship's query, from where the syllabus was bought. Under which particular way you bought the syllabus. Now, first later on I'll come. First, I'll give an answer to that whether there is a violation of the AICT regulation, whether past count services is required in level 9 and level 9B. This is what my learned friend has said. It is not required. Pass count services is only in level 11, not in your level. What is showed, my lord? Your lordship will kindly see at page 22. Just recollect, my lord, at page 22. My learned friend has showed at page 23. 23 qualification. At page 23 of the repetition 2286. 2286.
Yes.
This is what my learned friend has first opened up his case. He has given a reply showing at page 22 and 23 that qualification. Level 9A, BE, BTech in relevant discipline first class equivalent and level 10 bachelor and so and so. So now thereafter, my lord, he showed about scale of pay. Level 9A, 56,000, level 10, 57,000. Now, what he shows thereafter is about, my lord, that my pass count services, so far as this advertisement is concerned and we are concerned, is level 9A. So your pass count services will not be counted. It will only be counted, which my learned friend has shown at page 53. At 4.3. On the top, minimum qualification of lecturer senior scale level 11. I think, my lord, that's what my learned friend is showing, has shown before your lordship. So this minimum qualification of lecturer senior scale level 11, only pass count service is counted. But I just give a reply to it. Your lordship will now see what is level 11. What is level 11? What is it? Kindly see at page 46. What is level 11? Kindly see 46, serial number 3. Lecturer senior scale level 11. Lordship got it? It's promotion. So level 11 is promotion. There are two things which I have showed before your lordship. Now, if your lordship kindly now see at page 50, which I argued, page 50, this is your lordship will keep in mind, this is in respect, level 11 is respect of promotion. Now, kindly see at page 50, what was my argument? 2.22, counting of past services for direct recruitment and promotion. So here, my lord, two things. Pass count services will be in respect of direct recruitment as well as promotion. Level 11, nowhere it is a direct recruitment. It is in promotion. Lordship has seen level 11. So my learned friend said, level 11 is only counted in respect of pass count services. And that too, my reply will be, it is in respect of promotion. We are on direct recruitment, my lord. This level 9 is in respect of direct recruitment. Now, whether level 9, my lord, whether direct, my pass count services can be counted so far direct recruitment is concerned. I'll say humbly that yes, in level 9A, my pass count services will be counted. And to that, kindly see again, my lord, 2.22, previous regular service, whether national or international as lecturer, assistant professor, associate professor, HOD, workshop superintendent in a university, college equivalent post in national laboratories or other scientific professional organizations such as so and so shall be counted for direct recruitment and promotion of a teacher as lecturer, head of department, principal, or any other nomenclature provided that. So, Mala, suppose I am a regular, I had some regular service, I worked in somewhere as regular service, whether national or international. So if it is in respect, If it is a lecturer I worked as assistant professor, I worked as associate professor, I worked as HOD. Kindly see what previous regular service. So my past count services will be counted. My lord, shall be counted. Kindly see the word shall be counted for direct recruitment and promotion of a teacher as lecturer, head of department, principal, or any other nomenclature provided. So, my lord, if I have worked in some of the institution as a lecturer or an assistant professor or associate professor or HOD, then, my lord, in case of a direct recruitment or a professor, my lord, if he applies, then, my lord, he will get the benefit of past count services. This is what 2.2 says. 2.22 says. Now, provided that, my lord will kindly see 1A, qualification for the post held should not be lower than the qualification prescribed by AICT for lecturer, head of department, and principal, as the case may be. So, my lord, the qualification has to be looked into it. That qualification which I have applied, my lord, it should not be lower than the qualification which is prescribed, where I applied. B, the post was his equivalent grade or the pre-revised scale of pay as the post of lecturer, head of department, or principal. C, the candidate for direct recruitment is applied through proper channel only. D, the concerned person should possess the same minimum qualification as prescribed by AICT for appointment to the post of lecturer, head of department, and principal, as the case may be. E, the post was filled in accordance with prescribed selection procedures as laid down in regulation of the state government, central government, concerned institution for such appointment. F, the previous appointment. Now your lordship will put a pause for a moment till E. So, my lord, what is the E says 2.22? My lord, suppose I have worked in a particular college as a regular employee. Now there is an advertisement for the post. For a post of assistant, either assistant teacher, assistant, my lord, a lecturer or a lecturer, I can apply, but basic qualification should be what has been prescribed. I cannot go beyond the basic qualification. Now, 2 also says the revised grade so and so, head of the post was equivalent. So there cannot be lower. So these are the conditions which has to be fulfilled. Then, my lord, what will happen? Then my past count services will be counted. Now, if you, what I showed before your lordship is respect of F1. The previous appointment was not as a guest lecturer for any duration or ad hoc or in leave vacancy of less than 1 year duration. Ad hoc or temporary service can be counted provided that the period of service was more than 1 year duration. Now, my learned friend argument was that I have to fulfill 1 to 6. This is what my learned friend has argued. It cannot be 2.22F cannot be read isolation as 1. It should be read. That means he said you have to fulfill 1, you have to fulfill 2, 3, 4, 5, 6. All you have to fulfill. You cannot say that your argument period of service was more than 1 year duration. You cannot take that argument. You have to show before the court you fulfill. Now I'll show, my lord, how I fulfill all these conditions. And 4, 5 has to be read in isolation. It cannot be read together. First, I will show 1. The period of service was more than 1 year duration. Now kindly see, my lord, my appointment. Kindly see my, I'll show 1 petition, my lord. That makes, this is all same. All will be same. I'll show it. Polytechnic, no? I'll show 1 polytechnic case, my lord. It is almost same. That's point. Polytechnic. Into page. Now, my lord will kindly, these are also polytechnic, kindly take up 3051. 3051. Keep this also, my lord. Kindly keep 3051. Into asset page. Okay. Your lordship has taken up.
Yes.
Oh, no, okay. Lordship got it, my lord. Now kindly see page 45 first. 45 is the 2020 advertisement where we applied under 3F. This petitioners, my lord, all these are all polytechnic, my lord, which I have argued in that case also. Now we say, which I was arguing that 2286 also, these are also polytechnic. So this 2020, the advertisement, my lord, have seen this advertisement. I applied for this advertisement, and accordingly, at page 47, kindly see 47.
Yes.
Kindly see 47, my lord.
Yes.
This is 22nd of February 2021. What you got it? Subject to so and so, in the scale of pay of 57,700, 2 rupees so and so plus other allowances as admissible temporary for a period of 4 months, so and so, so and so. So this is 2021. 21. I'll demonstrate your lordship that page up to page, my last extension, which was given at page 54.
Yes.
54, kindly see 16 to 2023. So F 2.22 F1, I fulfill. The period of service was more than 1 year duration. So I demonstrate, my lord, this is more than 1 year. 2023, still it is going. Right, my lord? This is one. Number two, now kindly see number 2. The incumbent was appointed on recommendation of duly constituted selection committee. Is the same, my lord. Same writ petition your lordship will take up. That same writ petition.
The 3051.
3051. That's it will be easier to demonstrate with those clauses. The period of at page 50, that at 47. Now your lordship in one hand, your lordship will keep page 50 also of that case, or of the case which your lordship I have shown 2.22. So 47 kindly be seen, my lord.
Yes.
So these are the on recommended duly selected by the my lord by duly constituted selection committee. I was selected from page 47. That is why a written test was held. What is it? Written test was held in this case, my lord. So I applied for written test. I qualified for written test. Thereafter, I was appointed. So number 2, I fulfill, my lord. I fulfill number 2, 2.22 F2.
Yes.
Now kindly see 3, my lord. Selected the permanent profile. So my lord will kindly see 3. So number 3, the incumbent was selected to the permanent post in continuation to the ad hoc or temporary service. So my lord, our services, if your lordship kindly see 47, is a ad hoc. But this post are permanent, if your lordship kindly see 47. Subject to receipt of final police verification discharge without any reason, the following person appointed temporary as lecturer under regulation 3F, so and so, in the scale of pay, plus other as admissal temporary for period of 4 months, so and so. My lord, these are permanent posts, but appointed ad hoc or temporary. So I fulfill number 3. Now, interesting number 4, kindly see. It is not that you cannot count each and every. Number 4, kindly see, is totally different. And kindly see 4. An artificial break at 2.22, my lord. Lordship, kindly see 2.224. An artificial break in service shall not be used to the prejudice of employee appointed on permanent basis. The person appointed on permanent basis shall be given the benefit of entire service rendered by him with effect from the date of initial appointment, temporary contract ad hoc, notwithstanding the artificial break in service. So how this 2.22F can be connected with 4, my lord? If we see 2.22F1, the period of service was more than 1 year. And if you see 2.22F, ad hoc or temporary service can be counted provided that. So, my lord, my ad hoc or temporary service can be counted, fulfillment of 1, 2, and 3, but 4 cannot be, my lord. 4 is regarding about permanent. An artificial break in service shall not be used to a prejudice of the employee appointed on permanent basis. The person appointed on permanent basis shall be given the benefit of entire service rendered by him with effect from the date of initial appointment, temporary, notwithstanding artificial break in service. Now, if you see 5, the incumbent was drawing total gross emolument not less than the monthly gross salary initial stage of a regularly appointed lecturer, head or department principal, as the case may be. Now, my gross emolument, my lord, if your lordship kindly see at page 47, is like a permanent employee. I am getting a pay scale of 57,700. So it is what emolument, whichever a regularly appointed lecturer used to get after promotion, head of department used to get, I get this scale of pay. But this is not a head of department, it's a case of lecturer. So whatever lecturer gets, my lord, the scale of pay, same scale of pay under 3F also we get it. So this also fulfills the condition. 6N, at the time of selection, negotiate terms and conditions clearly mention the period of experience. Nature of experience the same has been consented by the employer. There is no dispute about this. So I didn't trouble your lordship, but I thought that as my learned friend has pointed out, all has to be read. I think all cannot be read. It has to be read in isolation. Even then 1, 2, 3, 4 is completely on a permanent employee. Even for an argument's sake, my lord, we are a temporary employees. Temporary employees also, there is no break in service. As on date, there is no break in service. We are continuing, we are going on full swing. There is no break in service. So even we take it 4 also, artificial break in service shall be not be used to the prejudice of the employee appointed on permanent basis. So definitely, my lord, we cannot be appointed on permanent. We are ad hoc or temporary, but even an artificial break, so for ad hoc or temporary is concerned, then the situation will be different. There is no artificial break so far ad hoc or the temporary employees are concerned. So all this 2
part, what does it mean that 4,
yes,
the second last line,
yes,
date of initial appointment,
that which one, my lord?
within bracket, temporary contract ad hoc.
Yes. Yes. 4, 5 more 4. Yes. The person appointed on permanent basis shall be given the benefit of entire service rendered by him with effect from date of initial appointment, temporary contract ad hoc, notwithstanding the artificial break break-in service. My lord, I am appointed a temporary ad hoc and there is no break-in service, my lord. So my appointment, which was the initial appointment, my lord, I should get all the benefit. Kindly see, the person appointed on permanent basis shall be given the benefit enter service entered by him with effect from date of initial appointment, whether temporary contract ad hoc, notwithstanding the artificial break period. Suppose, my lord, I have worked for 4 months. There is a break of 1 month. Thereafter, again, my service, again, they extend my service. There will be a break. So I will not get the benefit. So who will
No.
get a benefit? So where there is no break in service.
So you are not covered by this break.
No, my lord,
Only thing I wanted to know is
I-
initial appointment and it says within bracket contract.
yes, my lord, there is no break in service.
Oh.
So I will, my lord, whatever, my lord, if there is a break in service, then situation will be different. Here there is no break in service. We are temporary ad hoc, but my service as on date, there is no break. I still continue. So my lord will kindly see once again, the person appointed on permanent basis shall be given the benefit of entire service ended by him with effect from date of initial appointment, temporary, contract, ad hoc, notwithstanding the artificial break in service. Now, my lord, 5, 6, I have explained, my lord. Am I clear, my lord? Is your lordship is clear about this, my lord? Your lordship can put whatever your lordship can query, put a query to me. I can give an answer to it, my lord. This is what my learned friend has said. Learned friend has said, so far as the first point is concerned, again, I am just reiterating the point. There is no violation of the AIC regulation, as experience is required only in recruitment in entry-level post of lecturer, not in entry-level 9 and 10 as per advertisement. So my learned friend says, only what the benefit will be given only in level 11, not in entry-level 9A or entry level 9 and 10. But I have shown, my lord, it is not in respect of 2.22, it is respect of counting of my services as a direct recruitment and also promotion. So reiterate, my lord, if I have been working in some other department, in some other institution as a lecturer also, and if I apply a lecturer here, my lord, then as a direct recruitee where I have applied, my past count services, my past services will be counted if it is equivalent. The qualification cannot be lower. But if I'm ad hoc or temporary, which is 2.22F, my lord, my ad hoc or temporary can be counted if I fulfill this condition. But this condition is not that all has to be fulfilled. Otherwise, my lord will kindly see why there is 5. If your lordship kindly see 5, the incumbent was drawing total gross emoluments not less than monthly gross salary and initial stage of a regularly appointed lecturer, head of department, principal, as the case may be, and at the time of selection, the negotiated terms and conditions clearly mention the period, experience, nature of experience, the same has to be consented by the employer. So, lordship seen under 3F, we are getting a pay scale of 57,000 to 1 lakh, which a regular appointee also is getting it. Now I'll tell one thing, my lord. The petition of which I moved in respect of 2286, they are not under 3F. But if we, even if they are not in 3F, I'll show, my lord, if you have worked more than 3 hours, and my lord, there was a grievance met out those employees who have been, my lord, appointed, not under 3F, but they have been appointed, not by 3F, but by on a contractual appointment. But there was a grievance that they are not getting the scale as of those under 3F. Then there was a circular which was issued and said, no, they will also get the benefit because those employees who were working, the contractual employees who was working as a guest lecturer or a lecturer, to those that of the 3F in this particular case, because their work is same. Whoever has more than 3 hours, has given more than 3 hours in a particular college, he will get an amount which is 75,000 plus, so not less than 75,000. So he also is well covered.
Let us see this appointment 2866.
2 years appointment. My lord, these appointments in respect of 228 is not been given in 2286, my lord, because they are also the polytechnic lecturer, my lord. There is no dispute on it. I can show it. There is no problem. Subsequently, I can bring it. There is no problem.
You
My lord, at
appointed,
page 13, page 13, kindly see, I made a statement. Page 13. Page 13. Page 12, kindly see para 5. Para 5. That the petitioner begs to that they have bona fide belief in the technique teaching province test, the ASERB will include such provision as per AIC notification for counting, as all the petitioner are working more than 4 years, and also include provision of 5 non-compounded increment as per AIC notification at the entry level. But to the utter surprise, the ASERB issued the recruitment notice specifying the syllabus, including a subject which are offered to technical teachers at the time of training by so and so, and prepared them for national so and so. So it is a fact that we have been working more than 4 years. There is no dispute about this, my lord. There is no dispute on it.
will this petitioners in this present petition
Yes.
cover F2?
F2. Yes, yes, my lord. F2. Also covered. We covered, my lord. We can give we can subsequent, there is only, we can show it, my lord. We can show before the court. We can assign. We have, if your lordship want, we can produce it. There is no problem. So, my lord, all this they cover, my lord. All this F 2.222, F 123, they all cover. And 4, my lord, is in respect of permanent basis, my lord. Even I argued, my lord, artificial break-in service, if you take the instance of ad hoc or temporary, there is no artificial break-in service in respect of ad hoc or temporary. Then your lordship has put a query on 5, this, on 4, this, my lord, what benefit the person shall be given the benefit of entire service rendered by him from date of initial appointment temporary contract, notwithstanding the artificial break-in service. So this is, I made it clear, my lord. So my humble submission before your lordship is that 2.22, as on date also, my lord, it includes the benefit to those direct recruitment under level 9 and level 10. And level 11 is completely different in respect of promotion. 11 also, level 11 also, in respect of promotion also, their past their past services will be counted. It is not a case that in level 9 and 10, level 10, the past count services will not be counted. If that be the case, my lord, first point, there is a violation. There is a violation of AIC regulation, or as experience required in level 9 and level 10 has not been counted by them. So far as teaching proficiency test is concerned. So if there is a violation, your lordship need not go to the other aspect of the matter. What your lordship can do it. Your lordship will not that no, you have to do this. Your lordship will remand the matter back to them, saying that do it in accordance with the ASAP, the ASA regulation. Your lordship cannot enter into and set those. No, you have to do in A, B, C, D. Your lordship can't under judicial review. Only what your lordship can do it if there is an ambiguity in the advertisement, because recruitment notice is also one part of the advertisement. If there is an ambiguity, then what the court can do it? The Supreme Court said the court only can give a direction to the authority. Your lordship will not set out that this is what you have to A, B, C, D. No, you will give a direction. On the face of it, I have to satisfy your lordship that this is not a case. There is a violation. So clearly I have demonstrated that there is a violation of the AICT regulation. If there is a violation of the AICT regulation, that's the end of the matter. You don't have to go to the second, third point. That's the end of the matter, my lord. Because your lordship now, kindly see, my lord, the second point. This is the first point. So there is a violation of the AICT regulation. Now, the second point, which my learned friend has raised, that candidate appearing the written test will have to appear also in teaching proficiency test. So, candidate cannot say, my lord, what criteria in a selection process. It is the power, state power to adopt the norms of selection.
Yes.
Right, my lord? Now, what they said, that AIC does not lay down the process, the recruitment process. The AIC process of recruitment is not laid down by the AICT. We lay down. It is not laid down. So, in absence of statute or the rule, which is not been prescribed by AICT, is a prerogative of the state to lay down the recruitment process, the process of recruitment. So no one can question. Very well, my lord. Let us accept that it is their prerogative. How they have said that your lordship will look into it. That's what precise I said. I am not making a new argument for lordship. Now your lordship recollect what argument I made. In this case, in 2286, if your lordship kindly see page 24, that was my argument. The process of recruitment. Now, your lordship recollect that there are two tests. One is OMR and MCQ, which you get 75 marks. Now, your lordship kindly clearly written down OMR MCQ based question papers booklets will contain 75 question carrying 1 mark for each correct answer. There will be negative marking of 0.25, 1/4 marks for wrong answer against each question. Only shortlisted candidate will be called for teaching proficiency test. What do you mean? What is this? This is what I understand, that OMR MCQ, my lord, there is a 75 mark. There is a negative mark also. So suppose, let us say for an instant, there are 1500 candidates. Out of 1500 candidates, 1000 candidates are selected. Because there are all are only those 1000 candidates out of 1500 will be shortlisted so far as proficiency test is concerned. They can, what is my argument? What is the argument of my learned friend? It has been completely, it has made a somersault by bringing the recruitment notice something else. Kindly see the recruitment notice, what it has been brought by them. This is what precisely I argued, my lord. Kindly see 66, my lord, which is put to challenge. That one teaching skill proficiency test is to be treated as an integral part of the test to be conducted for selection. Thus, the final merit selection list will be based on gross performance in 2 tests, OMR MCQ based written test and teaching skill proficiency test. Absolutely no problem. So, my lord, what happens? There are 1500 candidates. For an example, 1000, my lord, qualified because of the OMR MCQ test. And what they will do, out of that 1500, 1000 qualified, so they will be shortlisted and called for the proficiency test. Now, kindly see next. All aspiring candidates will have to appear in both the tests. all aspiring candidates in OMR MCQ based written test will be shortlisted to appear innovative written teaching skill point in a level playing field with no marks on interview. So my lord will just remember. So what my learned friend is said in their affidavit also is a level playing field. What do you mean by level playing field, my lord? Level playing field means OMR MCQ test, all will appear. There is no question, my lord, of a shortlisting. Level playing is all equal. So whatever all will appear, there is no question whether you pass, fail, no question, there is no question 75. All will appear and all has to appear in this, in the proficiency test also. So what my submission before your lordship is that this is absolutely, my lord, is contrary to what your advertisement says. So, my lord will use this word. There is no ambiguity. Your lordship will kindly note down the word. There is no ambiguity in the advertisement. Recruitment notice vis-a-vis the advertisement which was issued first at the first instance. Recruitment notice is subsequent. There is an advertisement for the post on 20 on. Your lordship will kindly see the advertisement is on 21 to 2023 at page 22. No, I think no, I think no. Subsequent 2019. My lord, kindly see on 21 to 2023. Correct, my lord? This is the advertisement. There is absolutely no problem. We accepted the advertisement. At page 24, your lordship again will see OMR MCQ, no problem, absolutely. Now, what they make in recruitment notice, now they said, in their affidavit, what is the affidavit, my lord, stand they have taken? Kindly see affidavit. Kindly see for a moment in affidavit, what stand they have taken. What is stand they have taken? No, more affidavit. Kindly see this stand in the affidavit, my lord. Kindly see at page 116, paragraph 8. No, 8. Kindly see 8. That with regard to the statement made in para 7 of the written petition, of the writ petition, deponent based OMR MCQ based written test is a competitive where there exists no qualifying mark. See, my lord, see, this is totally, there is no ambiguity in the affidavit what they have said. If your lordship kindly see the advertisement, OMR MCQ, there is a mark, 75 mark. How they are saying in the affidavit there is no qualifying mark? 75 mark is given, negative marking is also there. So who will qualify? My lord, who will? If so, what it was notified that all, now kindly see, it was notified all aspiring candidate appearing OMR MCQ based written will be shortlisted to appear written teaching provisional test in a level playing field with no mark on interview so that no discrimination made to a candidate. My lord, there is no interview now. It's all by written. Interview, my lord, which is taken maybe biasness. So what they have said, they have wiped out that interview. Whatever they process, recruitment process, it will be OMR MCQ. Based on that, my lord, teaching proficiency test, that is also written. Now, this is contrary to what stand you have taken. So there is no ambiguity in the recruitment notice vis-a-vis the advertisement which is issued. When the recruitment notice, kindly see, it is on 23/4/2023 at page 66. So the advertisement was issued by you. Yes, we agreed to it. We said also, absolutely no problem. But when we came to know, one day before we set for a written this OMR MCQ test, then we came to know that this recruitment notice has been issued by them. And this recruitment notice there is no ambiguity with the advertisement that has been issued by them. If there is no ambiguity, and in the affidavit also they are saying something else. In the recruitment notice also something else, and the advertisement also says something else. So there is no ambiguity. So I will show a judgment to this second, my lord, the proposition which my learned friend has, my lord, has put forward before the court, and the judgment which my learned friend has cited. I will not cite any of new judgment. I will just distinguish and which supports my case. For a moment, kindly, in connection with this, my lord, connection with this point, I'll take your lordship to my learned friend citation of 2019, 6 SSC page 350. (2019) 6 SSC page 350.
350.
Yes. No, sorry. Sorry, I'm sorry.
365.
Yes, yes. There you go.
362.
362, sorry, 362. See paragraph 9, my lord, which my learned friend has cited para 9. Kindly see para 9. The essential qualification for appointment to a post are for the employer to decide. Absolutely no problem, my lord. How an employee can decide the qualification? And your lordship has, I have shown, my lord, we are not disputing about my qualification or the qualification, how the ASAT has done it. No dispute. The employer may prescribe additional or desirable qualification, including any grant of preference. It is the employer who is best suited to decide the requirement a candidate must possess according to the needs of the employer nature of the work. The court cannot lay down the condition of eligibility, much less can it delve into the issue with regard to desirable qualification being on par with the essential eligibility by an interpretive rewriting of the advertisement. Question of equivalence will also fall outside the domain of judicial review. If the language of the advertisement and the rules are clear, the court cannot sit in judgment over the same. If there is an ambiguity in the advertisement or is contrary to any rules or law, the matter has go back to the appointing authority after appropriate orders to proceed in accordance with law. In no case, the court in the garb of judicial review sit in the chair of an appointing authority to decide what is best for the employer and interrupt the condition of the advertisement contrary to the plain language of the same, which I have said, my lord. I can just point out, and if your lordship is satisfied that yes, there is an ambiguity in the recruitment notice vis-a-vis the advertisement, definitely your lordship will not interpret that no, this A, they should do in this manner, B, they should do no. Your lordship will simply send it to them that this is not in accordance with the advertisement or statute, something has been laid down by the statute, then your lordship will say, yes, it is not in consonant with the statute, so we are sending it. This is what this, my learned friend read, this is helps us. As qualification, there is absolutely no problem in the qualification, my lord. So this is what my learned friend has shown the judgment. I think this helps, particularly our case. Now, second, my lord, third point, regarding about the syllabus, my lord. I think a lot of things has been said in respect of syllabus. There is no answer to it from where they brought this syllabus. This is what repeatedly your lordship has asked. A lot of things has been said for syllabus. It is a duty of a lecturer or anyone. He should know how to articulate. He dealt with those students, so he's more experienced. So he's saying about us, we are more experienced. What you are saying that from where you bought this syllabus? So there is no answer to it. And the judgment which my learned friend has relied on the judgment of the the state can put the criteria of selection process that I have shown. Judgment is not clear, sir. No, okay. One judgment which my learned pen has shown is 2010 3 SCC page 104. I think this is completely on a different footing altogether. Paragraph number? Paragraph 11. Kindly see what is paragraph 11, my lord. Kindly see what is paragraph 11. State of so and so, court held a commission board has to satisfy itself a candidate has obtained such aggregate marks in written test as to qualify for interview and obtain sufficient mark in viva, which would show his suitability for service. Such a course is permissible for adjusting the qualities capacity of a candidate. It may be necessary in view of the fact that it is imperative that only person with a prescribed minimum of said quality capacity should be selected, as otherwise the standards of judiciary would get diluted and substandard staff may get selected. Interview may also be the best mode of assessing the suitability of a candidate for a particular position as to bring out the overall intellectual qualities of the candidate. Now, my lord, there is no written test, there is no oral test here to find out the intellectual, my lord, qualities of a candidate. While the written test will testify the candidate academic knowledge, the oral test can bring out or disclose overall intellectual and personal qualities like alertness, resourcefulness, dependability, capacity for discussion, ability to take decision, qualities of leadership, etc., which are also essential for a judicial officer. So this was appointment to the post of district judge, my lord. So there was two tests, one was written test and one was viva. So what is written test and what is viva? So I think this is completely on a different subject. Now see paragraph 15, which my learned friend has relied. Thus, the law on the issue can be summarized to the effect that in case the statutory rule prescribe a particular mode of selection, it has to be given strict adherence accordingly. In case no procedure is prescribed by rule and there is no other impediment in law, the competent authority, while laying down the norms for selection, may prescribe for the test and further specify the minimum benchmark for written test always as viva. So what they want to say, if there is no prescribed procedure which has been laid down either by ACT or by AICT, then we can lay down as we have laid down in this particular case. But my lord, this case has to be looked into it. What is the subject matter of this particular case and what is the subject matter of our case? The facts has to be looked into it. Principle has to be applied, but it has to be connected with the facts of the case. Here, my lord, it is the appointment of a district judge. The facts is completely different. It is about a written test, finding a suitability of a candidate, and when is a question of an oral interview, then your intellectuality has to be looked into it. So there is no question of any oral test. It is all written test. From where they found, what is the answer to it? So I think this is completely on a different footing altogether. Okay. Yes, my lord, another judgment which my learned friend has shown is 2021 2 SCC 564. It large judgment. 2021 2 SCC 564. Paragraph was related. Paragraph 47.
Yes.
47 and 58. I'll not trouble your lordship. This is in respect of some admission 47 and 48. 48, 1, 48, para 48,
It is 47.
48, 47. Yes. It is only related to admission. That even the state government can prescribe higher standard than those prescribed by AICT were recognized. Three-member bench of this court. This principle later applied in the case of university, where the court considered previous decision, summarized the legal play emerging them as follows. While prescribing the eligibility criteria for admission in institution of higher education can adversely affect the standard laid down by the central body AICT. So, my lord, the higher standard can be laid down by the state. So, in respect of some admission, my lord. So, I think this is not connected with this particular case. AICT, my lord, state can lay down a higher standard. Arun, same legal. 2004, 4SC 513 also is same, my lord, is respect of admission. Paragraph 9 and 10. Nine and 10. Nine and 10, man. I'll not trouble your lordship. This has no connection with the present case. Yes, please go ahead. So, my lord, and one thing last, I just draw your lordship attention to his affidavit which has been filed. The state affidavit has been filed. As on date, there is no answer to it. That what do you mean by weightage of 75 marks? At page 115. Kindly see the first on the top. As per the said advertisement, weightage of 75 mark on OMR MCQ written examination, 25% weightage of teaching points is given, and there is no provision for interview, ma'am. What do you mean by weightage? And what do you mean by, my lord, weightage in both these cases? My lord, I have not seen anywhere a 75% weightage as given. I worked in that department, Now there is an advertisement which post. Suppose there are some fresh recruited who has not joined in the department, who freshly applied. So my weightage will be counted. My first count services will be counted. That do you mean by weightage? From where this they found, then as per the said advertisement, weightage of 75 marks. There is no case of weightage of 75 marks. Lordship, kindly see. So there is no ambiguity. What stand they have taken in the affidavit is contrary to what the advertisement says. So you cannot take a separate stand in the affidavit, my lord. You have to stick to your affidavit. You cannot improvise your case. This is what Mohindra Gill says, my lord. How can you improvise your case, my lord? Your lordship has seen in the advertisement, it is simply, it is a OMR MCQ based test and 75%. Where is that weightage? From where it is found, weightage? And my lord, weightage in so far as OMR and MCQ and weightage in teaching provision test. So these are something new they have taken in the my lord, the affidavit which they have filed. So my humble submission, I am not adding anything new argument. I am only giving a rebuttal to what my learned friend has argued. I think this particular 3 points which he has taken, that my lord is very fallacious. And my lord, my humble submission is that it may not be accepted by the court. Because if your lordship take the first point to sum up my argument, if your lordship takes the first point and finds that there is a violation of the AICT regulation, my lord, then that's the end of the matter. Then ends of the matter, my lord. If there is a violation of the AICT regulation, and I have shown, my lord, that it is level 9A and 9B also, my lord, there is also pass count service, it has to be taken. I have demonstrated. There is not 11, level 11 is respect of promotion, yes, but not in that why my pass count services will not be counted. On this first point, my lord, if your lordship decides in favor, lordship need not go to the second point of the case. And second, my lord, that there is no ambiguity in the recruitment notice which subsequently they have advertised. So in that case, 2019 Supreme Court says, my lord, if there is no ambiguity, your lordship will send back to the authority to again, my lord, they should be, it should be done in accordance with the procedure that has been laid down. And third, my lord, syllabus also there is no answer to it. Fourth, stand which they have taken affidavit is something else, which is contrary to the advertisement which has been issued. Because there is, I have not seen anywhere, my lord, in the advertisement, neither in the recruitment or in the advertisement, that weightage has to be given in both the test. So my humble submission before your lordship is that the recruitment notice should go and your lordship will send back to the authority to decide to again freshly recruitment notice, and it should be done in accordance with the procedure that has been laid down. That's my humble submission for your lordship. And my prayer in the writ petition is, if there is ambiguity, my lord, with the recruitment notice subsequently, if you read the advertisement, both should go, my lord. Because if you say something in the advertisement that both only shortlisted candidate, thereafter you have taken a different altogether recruitment notice, so there is no ambiguity. It should go. Let them advertise freshly, my lord. Or if your lordship feels that no, advertisement is there, recruitment notice should go. Subsequently, they have issued. That should go. That will, my lord. I think that's what my submission is. I have argued nothing new in this case, my lord. What only I have given a reply to my learned friend.
Just I clarify two things. One thing is came out from the selection in the regarding lordship writ petition. That was not argued earlier, lordship. So I have clarified it. 3051 lordship. 3051
I argued. My lord, yes, I argued.
regarding appointment part, just I clarifying one thing.
1 minute. This senior counsel, that with regard to 2866.
Yes.
2286.
Yes.
The recruitment process.
Your lordship wants the appointment.
Yeah.
We can give it, my lord. There is no problem. Yes, tomorrow. Tomorrow itself, we can just an affidavit giving to the other side also. No problem. What we'll do is, my lordship has, my lord has kept this particular reserve now. There is no question. Only I'll give it to my learned friend, to your lordship, with one affidavit, how my process of recruitment was done. That's all.
Invite somebody, the affidavit is not required. If they supply the documents, lordship,
Oh, fine.
that will suffice.
Very well, man.
Affidavit is not required because lordship will want to see whether what procedure is adopted. They have supplied the document already. Hearing is concluded, lordship. Now new document, nothing is required.
So it's okay. Your
They can
lordship is
supply it,
asking.
lordship. Even that copy, we also no need, lordship. They
Your
can
lordship-
supply that directly to the court also, lordship. We have no objection.
Okay, fine. I will give it to the court then.
We have no objection, lordship.
I will give to the court.
That answers your problem.
Lordship,
That answers your problem, isn't it?
lordship.
The issue which you're trying to raise.
No, lordship, that already I have argued that point. Just I have indicated, lordship, 3051. They have said that, lordship, that recruitment notification, page 45. I am not arguing, lordship, just I have pointed out, lordship, it was by the lordship directorate, not by the proper authority. Proper authority is the as per 2081 rules, it should be the commission. Commission is the Assam Public Service Commission, lordship. He is the proper authority to recommend the candidate. It was not recommended by the proper authority, lordship. As per the AICT's notification, lordship, just time indicated two things, lordship. AICT notification, it says that, lordship, the incumbent was appointed on the recommendation of the duly constituted selection committee, lordship. Duly constituted selection committee is the committee constituted by the APSC, lordship. Not by the lordship, other things. That point, And regarding other point also, just I am indicating one issue, Lordship.
What did us? Assistant by Ms.
My lord, may kindly peruse that writ petition, Lordship, 2286.
Yes, duty.
2286, that's one clarification, Lordship, 2286, Lordship. 2286, page 46, Lordship. Page 46, Lordship.
Yes.
2.1, Lordship. It is a CADA structure given by the IICT. Lecture 9A, direct recruitment. Lecturer 10, level 10A, promotion direct recruitment. Lecturer senior scale, and 3, 4, and 5 is the promotion, Lordship. Then my lord may kindly peruse 6, head of the department direct recruitment, Lordship. Then Lordship, principal says promotion and direct recruitment, Lordship. So Lordship, the counting of the past service, Lordship. My lord may kindly peruse the
That's
principal.
over, my lord. Argument is over again. What is this?
Principal.
my lord? Again, I have to start, my lord.
I am not lost,
Ah,
not
then-
new things, just indicated. I am just clarifying the position, Lordship. Petitioner says that 9A is required for entry level, is required for the expense part. As per the IICT, only expense part is required, Lordship. In case of promotion 3, 4, and 5, Lordship. In case of direct recruitment 6 and 7, Lordship. They have the prescribed the qualification which is required, Lordship. This is my submission. Only 2 clarification I have given, Lordship.
Okay. Also, for Commissioner. Standing council, higher education department. Five. KL is the MS. Standing council, AICT. Would respond number 7. And government. Government advocate. Respondent number 1. DD Babu. Hearing concluded. Judgment is.
My lord, the interim order will continue till the done.
Interim order passed ready to continue.
All the 3 cases will continue. All these cases, 3 cases. I'm deeply obliged. ma'am.
Interim order passed ready and all the week to continue.
May I please, Lordship. BTC council has come, Lordship. 14, 15, 16, Lordship.
You wait for your turn. Wait for your turn.
Item C and production list 1.
I can't hear you. No, I can't. Use the mic.
Lordship has directed me last occasion to obtain instructions, Lordship. In that regard, I have not yet received written instructions. As per verbal instructions, Lordship, it is the Health University, Srimanta Sankardev University, to Lordship, to reply this Lordship's query, Lordships. So Srimanta Sankardev University is to a party respondent, Lordship, to be a party respondent.
No, is that not a party already?
No,
Lordship,
Srimanta
before that,
Sankardev
Lordship,
University is not a party here, Lordship. Only ASU is a party.
Lordship, may I pray, Lordship? Last occasion, only question was that regarding NOC of the government for diploma in pharmacy course, Lordship. And Lordship was asked them whether the affiliation is to be granted by the Assam Science and Technology University or Sankardev University. Today, I filed a miscellaneous application, Lordship. One notification was issued, Lordship. Today, just I filed 1767, Lordship. I challenge also that, Lordship, because there are the judgment of the Apex Court, Honorable Apex Court on that regarding pharmacy course, Lordship.
Which
That-
order? Which order?
annexure, lordship. Page. 14, lordship.
Yes.
That copy I have received just now, Lordship. So let it come another day, Lordship.
Lordship, just,
Have you served copy?
Serve copy.
lordship, I served the copy,
When?
lordship,
When did you serve?
lordship today, lordship. Because
Whatever date,
yesterday,
lordship.
lordship, I filed the application, lordship. On that, lordship, just I am clarifying your lordship position. Lordship, at this stage, lordship, I rely on some judgment of the apex court, lordship, on that point regarding the granting of NOC, whether the state government role is
You are praying for quashing of this notification.
lordship.
Then we have to give them an opportunity
Lordship,
Lordship.
because this is a fresh IA.
Please,
Lordship.
Lord.
Then they'll have to.
just I have also filed additional affidavit.
That is
Additional,
an additional affidavit, but you're having a new prayer.
lordship.
They'll have to file a
Appeal
counter against this.
I served the copy, lordship, also that,
You must have served a copy,
Lordship.
but they have to file a counter, isn't it?
lordship.
Then
Apart from that, lordship,
you
But-
don't want them to file a counter affidavit
lordship,
against this,
against that, lordship.
against this IA.
Whatever decision, lordship, I pray, lordship, because this petition before your lordship, my only prayer is that regarding the NOC of the government, whether needed for diploma in pharmacy course. And
No,
while
Lordship,
the,
let the matter come day after
Just-
tomorrow, Lordship, Thursday. Then we'll reply, Lordship. And direct the petitioner to implement the health university.
lordship,
Himanta
it will
Sangharakar
take
Health
another
University.
lordship time, lordship, once after another, lordship. Already this notification was issued by the government, lordship, health department. And they are already party in the instant case, lordship. So if I'll satisfy your lordship, please, lordship, I may be allowed to satisfy your lordship on that. Whether regarding the NOC for diploma course, whether the permission of the government is needed for or not. That things, lordship, to be considered, lordship.
No, that's fine. But why are you praying for quashing this notification?
Lordship, actually, they are now come with this notification on 6/6/2023, saying that those institutions which they have applied for in other places, they should have to apply here in Shankardev University, before the Shankardev University for streamlining. And this is not a state subject, lordship. This pharmacy education is a central subject.
So that's why then let them come with the affidavit
Lordship,
against your IA.
IA, lordship. Apart from if, lordship, I pray, lordship, what about the main prayer, lordship, since I pray that regarding the NOC of the government for diploma course, that point may kindly be considered, because they will take time, lordship, for submitting the reply. In other matter also, they have not yet filed the affidavit, lordship. Or if they are possible, lordship, because I have stated everything on legal point, lordship, not on any other factual metrics, lordship. I only relied on some judgment of the apex court as well as the constitutional provisions regarding 254 and state list,
So you don't want this court to consider this notification.
lordship.
You want this court to consider this notification?
Yes, lordship. Because if NOC is granted, lordship, again, first of all, I should have to register myself for affiliation before the ASTU as per government guidelines, central government guideline. Then I should have to apply to the if this circular will remain prevail, then I should have to apply for them. So prior to that, since 2019, lordship, my application is pending before the Assam Science and Technology University. And on that point, lordship, just I am taking lordship time on that point, lordship, whether the state have any power on to issue such
So
notification,
that's why when I hear you,
lordship,
in
lordship,
the main writ petition,
lordship,
I'll have to consider this notification also.
lordship. So,
After that, if I find something is wrong with this
Lordship,
notification, I'll have
lordship.
to set it aside.
lordship, I pray, lordship,
Can I hear you today without giving them an opportunity?
no, lordship, I am not on that.
Then
I am not on that. Only my earlier previous lordship main writ petition, where I have again and again pressurizing that lordship regarding the NOC of the in diploma in pharmacy course. Just lordship, I'll place some judgment on that, lordship. if your lordship finds anything lordship, then
Yes.
for the kind consideration lordship, if feels lordship, then they may go for any, if the reply is needed for on that circular, or sorry, that notification, whether they have authority to issue the notification or not, on that point lordship can. But regarding NOC part, lordship, I pray lordship, that point may be decided lordship. And after NOC lordship, these things will come lordship. Because NOC, my application is pending before the ASTU lordship. Or day after tomorrow, let's my learned friend take my instruction lordship. Because other matters are also fixed on.
Lordship may direct the petitioner to implement the health university. That will be clear. Lord.
First met by MS Bora, the understanding council health department. We'll take it up on Friday.
Lordship, this is Friday. Friday, or because Friday, so many matters will be there, lordship, it may not be reached lordship. I pray lordship, it's a very urgent matter lordship,
Can you get instructions by day after tomorrow?
because other matters are already
Let
fixed
it
also.
come on Tuesday, next Tuesday.
No, next Tuesday lordship,
Tuesday.
on
Lordship.
26 lordship, I will be out of station lordship for Eid or holidays lordship. I pray lordship on Friday or
Friday.
Friday lordship, I will
23rd.
pray for upgradation also that lordship.
You have to impute the other party also, isn't it?
Lordship, ASTU is a party lordship. And Shankardev University is not needed for it is issued by the
No, Sankara
respondent
University
lordship.
He has
is
got the
an
instruction that
lordship.
it is the Shangardev University who is going to issue. this.
No, lordship, that notification was issued by the respondent who is now here a respondent lordship, commissioner and
Okay,
secretary.
it's up to you. If you don't want the impute, I have no problem.
Because it will
So
take
if-
more time, Shankardev
if
University then will
impute
come
is-
lordship, because they are representing everybody lordship.
This court has directed you to make your implement. If after that we
At
find
this
that
stage, lordship,
the
let her,
party is required, then
I-
I'll have to dismiss this
Lordship-
with petition on that's all.
lordship on
In
that
that
lordship,
case, which case was this, 1960? Yeah,
lordship, already ASTU is a party here.
already this court has
I don't know.
told you
Lordship,
that this Shangardev may be a necessary party.
lordship, let
He
my.
has refused to make
I
it a
pray,
party.
with all
and
respect, lordship, I pray, let my learned friend take instruction, if anything, lordship, then subsequent,
She has taken instructions and she's on the basis of instructions, she's submitting. That is the reason why.
lordship, because I have not yet applied before the Shankardev University lordship, they have no role to play lordship in my case. My case is advanced is before the ASTU lordship.
You, by day after tomorrow, you'll get the written submission,
Lordship.
written
Lordship.
instructions. By which date? You know, the standing council health department shall have. completed the instructions.
It's Friday, Lordship.
Friday.
Obliged, Lordship.
Much obliged, lordship.
7.
May it please your lordship.
Yes, what is this matter?
This matter, my lord, I have challenged the selection of the respondent number 5, my lord, as principal
Oh.
of higher secondary school, my lord. He has been given wrongly, my lord, the mark. He has actually, there is a column, my lord, that 5C. If he has worked as in charge principal for a period of 1 year, he will get 1 marks more. He can be added 1 marks, but that is limited to 3 marks. In this case, my lord, he has worked as in charge principal only for a period of 6 months, but he has been given 1 mark.
Where is
So-
that? Where is that?
Yes, my lord, the notification. It is, my lord, in annexure 12, page 42, my lord. Relevant paragraph is the office memorandum 26 December 2018. Here, my lord, the last column, page 43. Column 5, my lord. Plus
Eight.
5, experience marks. Here, my lord, 3, A, B, and C. Experience as in charge principal. 1 mark for each year of experience subject to maximum 3 marks.
Hmm.
So 1 mark for each year of experience. he has completed 1 year as in-charge principal, he has to be given 1 marks for the experience as in-charge principal. But in the present case, my lord, he has worked for, my lord, at paragraph 17 hereby repetition,
Here it says 1 mark for each year
1 mark for each year,
of experience subject to maximum of 3 marks.
3 marks.
So
He has
if,
worked
if
for 6 months.
somebody has worked as in charge principal for 4 years,
Yes, ma'am. He will be
he will
given 3
get a
years.
maximum
3
of
marks.
3 marks.
3 marks, yes. In the present case, my lord, paragraph 17, I have stated, my lord.
Your grievance is that only?
Only that, limited, my lord. Paragraph 17 at page 15, my lord, of the writ petition. Earlier also, he was appointed as principal, that was set aside by this honorable court, my lord. Again,
Paragraph
the-
17.
yes, my lord, page 15.
Oh.
That the petitioner begs to state that Sri Jayanta Saharia Santa Responder 5 judgment and order that 12 March 2019 was reverted to his original post, which was implemented by the order dated 28 August 2019, file memo number so and so. Thereafter, the post of principal was advertised on 12/9/2019. It is important to note that respond number 5, from taking over charge of principal to selection of principal, that is till 4th March 2020, he has been appointed as in-charge principal, has completed 7 months. Actually, it should be 6 months, right? 6 months only as in-charge principal, whereas as per clause 5, so and so, 1 year mandatory service is necessary for granting additional mark during selection. As such, the respond number 5 has not completed the period of 1 year mandatory service continuously as in-charge principal.
When was
He-
respond number 5 appointed as in charge principal?
He was appointed as in-charge principal on 4th of March 2020.
Then
Then, my lord, he continued, my lord, to no, my lord, he was appointed as, my lord,
who is the advertisement?
advertisement is, my lord, at page 35, my lord.
Read it.
Is as per order dated so and so 12/3/2019 passed by Honorable Guwahati High Court. Guwahati so and so, Jayanta Saharia has reverted to his substantive post of subject teacher from the post of principal by Director of Education BTC Kokrajhar, letter dated so and so dated 4/9/2019. Hence, the post of principal of Kolaigaon Higher Secondary School is lying vacant. Accordingly, as per order issued by the Inspector of Schools ADC Odalguri, had order so and so, 9th, under reference to letter dated so and so, 4/9/2019, asks to principal in-charge to submit the seniority list of teachers of Kolaigaon along with relevant documents as per performer for selection of principal of Kolaigaon Higher Secondary School, which is lying vacant. So aspirant teachers of Kolaigaon so and so hereby informed to apply with relevant documents for the post of principal of Kolaigaon Higher Secondary School to the undersigned on or before 14/9/2019. All the particulars should be 2 copies. so and so.
Which rule governs the selection of principal of school, higher secondary school?
Beg your pardon?
Which rule governs the selection of?
Kolaigaon Higher Secondary
No,
School.
no, which rule?
Higher Secondary School.
Yeah.
Which rule?
Which rule? Rule, my lord, it's actually, my lord, 2018 rule is, my lord, 2018 rule is applicable as per BTC.
What
There are two
2018,
affidavits.
what 2018 rules?
Yes.
Page,
And state of Assam. Eighteen, my lord, page 18.
18.
Yes, ma'am.
Advertisement to Agor.
Then is, my lord, that particular section is, my lord. 14.
Probably your lordship, 2003 rule will govern the selection. Your
That
lordship.
is confusing. Assam has my lord filed an affidavit. Standing Council, State of Assam has filed an affidavit that my lord 2003 rule will be
Because
implemented.
the advertisement was issued on 12/9/2019, and the 2018 rules came on 10th October 2019. Just after the publishing of the advertisement, the advertisement
So
issued
2003
prior to
rule
the
will be
18th
applicable.
rules came into force.
2003 rule,
Three will come.
2003 rule.
with the rule.
Then also, my
Page
lord,
your lordship 373. Your lordship will get it at 363 of the book.
কিমান আছে, হে?
Yeah,
I have quoted my lord, the rule I have quoted.
2003 rules.
Yes, man.
Where's the post, equipment to the post of?
Principal,
Rule 13.
rule 13. I believe in this. Petition that will be put.
So it says advertisement to be published at least in 2 widely circulated local newspapers. Now, as per the reading of this 13:1,
Yes, my lord.
it is an open advertisement, isn't it? Whatever,
Lordship of the-
it is not confined to the school only.
No, no.
Then this advertisement also is wrong, is it? Is it not? This advertisement is also wrong. See the last paragraph.
Lordship.
So as parent teachers of so and so school, I have.
As per your lordship,
It says. as
this is
parent
advertised by the
teachers.
your lordship school selection committee.
School selection committee,
School
there's no doubt on that.
Lordship.
But it says that through an advertisement to be published at least in 2 widely circulated local newspapers. So it means it's an open advertisement, it is not confined only to the particular school.
That.
Anybody can apply, isn't it? SMD,
Yes,
history,
Yes, man.
it is not confined to a particular school.
Confined on particular school, my lord. It should have been an open advertisement.
Moreover, lordship, that selection process is under BTC, so state government has no role to play so far as the selection process.
But then this rule,
This will follow.
so according to you, what is,
Advertisement.
what do you
no.
say, Mr. Chishti?
Yes, lordship.
Is it confined only to the school concerned or it is an open recruitment process?
That lordship, that I have to go to
Read
it.
rule 13:1.
13(1) is there, lordship. School selection committee will, the school selection committee will advertise for the lordship. Yes, lordship, there's an amendment, lordship, that the directors, secondary, being a member secretary of state selection and that direct equipment.
Where's the amendment?
13, subsidiary rule 13 by Assam secondary to 12. In the year 2012, there's some amendment is there, lordship, like regarding section 13 procedure for selection of principals. In page 378, lordship, may kindly turn below, lordship. Intending an eligible candidate district wise to effect the rules.
Where is that?
Page 378, lordship, below the substituted rule 13 of Assam Secondary Education Professional Service Rule 2012, published in Assam Gazette on 10/7/2012, and before substitution read as
Section 13, procedure
270.
of selection of principals. Some suggestions were made, Lordship. Page 378, Lordship, in the green book.
District wise, clause 2. That has also not been done.
It should be a district-wise select list, Lordship.
No, সেইটো আগৰটো
Hmm?
এইটোহে পিছৰ পাৰত এইটো আহিছে
Barar এইটো আহিছে নেকি?
এইটো আছিলে prior to 12 এইটো আছে।
Whichever way it is, even before the amendment or after the amendment.
Lord, this is after the amendment. Your lordship will kindly see this rule is the
12,
rule 13 has been
19.
substituted.
Yes,
This is the original rule, rule 13, page 378 footnote. Procedure for selection. Before substitution, read as well.
so this was before substitution.
That substituted.
So after the substitution, it
It's
is
13, your lord.
page
Your lordship.
Page
has
377.
377.
377.
It clearly, তার ডিস্ট্রিক্ট ওয়াইজে হবে এটা। ধরাই দিব না, শহরে দিব লাগিব, স্কুল হলেও দিব লাগিব।
Yeah, Bora, what do you say?
মই তো খুবই লগ
Lordship, as per my instruction, Lordship, I have filed affidavit, Lordship,
Is it,
not
is it,
seen.
no, on the advertisement? Is it confined only to this Kalaigon Higher Secondary School or is it an open advertisement calling from the open market?
Not shown in newspaper, Lordship, as per my instruction.
So it was not shown in the newspaper.
Lordship.
And also the language it reads aspirant teachers of Kalaigon Higher Secondary School. So it is confined only to a particular school to apply for the post of principal, isn't it? It should have been an open advertisement.
Lordship.
So the advertisement by itself stands vitiated in terms of rule 13(1). Correct. And the principal, in charge principal could not have issued this advertisement. It was the member secretary of the school selection board.
School. He says,
I have got a verbal penalty, it is school-wide, Lordship.
What is it?
It is school-wide selection, Lordship.
The school-wise selection.
Yes, yes, Lordship.
How is it?
I have to check, Lordship, but I have got a letter from the director, Lordship, that it's a school-wide in as per total training.
Come to the mic, I can't hear you.
I have got a telephonic direction, conversation with the director, Lordship. He said over phone that it is school-wise selection, this Lordship. But I have to,
But have you read rule 13(1)? It is a school-wise selection.
yes, because the school selection committee, they will advertise losses and the seniority list will come from school itself only.
Does it say about any seniority list in these rules? 2003 rules.
That's a school lesson. 13 she says that the panel names are prepared by the school selection committee shall be forwarded to the concerned inspector of schools to the state selection board constituted sunshine. After receipt of the panel under sunshine, state selection board shall prepare select list equal to the number of vacant posts. Taken. It's- Yeah, my lord, otherwise also, your lordship may kindly see page 49, my lord. The comparative statement, my lord, of allotting marks. Page 49, annex of 14.
Let us come to this later on.
First, my lord, the rule.
Mr. Nair. Require your assistance. Come towards GST side. GST
Yes,
side.
yes, yes.
Rule মানে 30
এই 2000 প্রিন্সিপাল সিলেকশন অফ স্কুল ওয়াইজ মই কৈছো স্কুল ওয়াইজ হয়
Rule 13(1).
Lordship. Lordship,
You know,
Lordship.
see the advertisement and the writ petition. Last paragraph.
Page 35.
No, my lord, it cannot be. This cannot be limited to a particular school.
That's
but
what I must.
It will have to be for whoever is
And-
otherwise eligible. It's a direct recruitment post.
Who issued the advertisement?
The advertisement is by the principal in charge, Kalaigaon High School. Fine, no problem.
But then rule 13(1) says something else. Member secretary. School selection.
Member secretary, my lord, normally it's the principal
Oh.
who is the, my lord, member secretary. Normally the governing body, the member secretary. But my lord, here the problem is the last paragraph. It says, so aspirants, teachers of Kalaigaon are hereby informed to apply with relevant documents for the post of principal. So and so to the undersigned on or before 14/9/20, all particulars should be disposed. There should be of 2 copies. So this cannot be confined to that school only. my lord. This has to be open to all the eligible teachers wherever they are, maybe in the district or maybe outside also, my lord. They'll apply, then my lord, school-wise selection will take place. For headmaster, it will be only for the graduate teachers and graduate teachers in that very school. But for principal, my lord, this last paragraph is not maintainable. And this advertisement in all probability was not given in the newspaper or somewhere, my lord.
Yes,
What not a decision in the newspaper?
no idea.
There has to be publicity, my lord. My lord will have that one totally, my lord. Before the end of each year, the member secretary of the school selection committee shall invite application from the intending eligible candidates through an advertisement to be published at least in 2
At
widely circulated local newspapers.
At least in 2 widely circulated local newspaper. That has not been done, my lord.
Ivansky.
Yes,
we run some more selection.
GST.
It's under BTC. We have no role to play in the-
With the separate rule, sir.
Gora, no?
Director of Education, Inspector of School,
Good,
DC
sir.
Utalpuri, Notice Board of Palaga Higher Secondary School, and Office Factor. No, they protest.
Copy, my lord.
So far as this is not, this was not
Notice
a
board.
immediate case, you know, since there's.
Only notice board,
Today, your
not
lordship,
newspaper.
this, your lordship, this point, your lordship, it has not been raised in the pleadings, your lordship.
This court is noticing this.
Yes, your lordship, that's
What is
since
raised?
your lord, this has fallen from
What
your
is
lordship's
not?
mouth and your lordship has noticed it, your lordship. Let me, your lordship, take an instruction on that also, your lordship.
Gora will have to take it. sir.
No, last occasion also that. point
No, no,
has
that
been
was
kept.
not the
That's why
issue,
my
your
lord,
lordship.
lordship asked to
Yeah.
file 2 affidavit.
Their marks was.
For the council.
Issue was your lordship marks, your lordship, in experience said, your lordship, whether I am entitled to get it or not. That was the issue, your lordship. Now, this is your lordship for the first time, your lordship, that has
Not
come up,
first
your
time.
lordship, and when your lordship noticed this point, your lordship. Therefore, your lordship, let me at least have some instruction, your lordship, whether that has been done or not, your lordship. Since now, no, that has neither been in the reply of the affidavit in opposition of the government or the school authorities, your lordship, no one has made any statement on that.
Third MS and cycle and the council for the petition.
Only 1 point, my lord. This
Also
issue
heard-
was raised, my lord, on my lord, lordship has on my lord order that your lordship will found 25/4/2003, my lord. This issue
25?
was argued 25 April
Hmm.
2023. Regarding the rule, my lord, that's why they were directed to file affidavit for the council.
Not that is
So
not
it
the
is not
issue.
that today that this has come.
Here, your lordship, issue as your lordship, whether
They want to
experience
continue Sama, my
at
lord.
all can be
Illegally,
granted
they
or
want to
not. That
continue.
was an issue. Your lord.
Also
issue
heard
is
Mr. SMT still understanding council. Taking to education. MS RB Bora, Learned Standing Council BTC, and Mr. S. Bartopur, Learned Council for the response number 5. Stop. The present writ petition pertains to the
Interpretation.
tussle for holding the post of principal in Kalaigon Higher Secondary School of Udalguri district under BTC, which was advertised by advertisement dated. What date is this? 12/9.
12/9/2019.
Stop. It is the consensus of the learned council for the parties that the said advertisement is governed by the Assam Secondary Education within bracket provincialization service rules 2003. Stop. A perusal of the advertisement as well as reading of the as well as a reading of rule 13(1) of the rules of 2003 would indicate that the advertisement is not in conformity with the requirements of rule 13(1) of the rules of 2003. So, accordingly, MS RB Bora, Learned Government Learned Standing Council BTC, is directed to take instructions. List the matter again after summer vacation. After summer.
So, my lord, set aside, my lord. They
Why should
advertise,
I- why should
my
I-
lord, because my lord already
You
it
have
is
not
not.
raised this issue in the
conformity.
writ petition.
Beg your pardon?
You have not raised this issue.
No, my
It
lord,
is
the
the
court
court,
has
it
raised,
is the
court has
court
raised.
taking up the matter today itself. And then I'm directing. them to
Last
take
occasion,
instructions.
my lord, on 25, my lord, the court also raised, my lord, which.
That was
will
in a
apply.
different rule. That was in the rule of 2018.
Yes, my. So let us fix a hearing
Public.
date on, my lord, first week of April, August, my lord,
Yeah, we'll see. This will come after the vacation.
after vacation, my
Public.
lord. August, can it be on 2nd of August?
After vacation.
After vacation, my lord, a date may fix,
No,
otherwise,
I'm not fixing data.
otherwise, my lord, we are finding in difficulty to get
You
the
can make your
matter
mention,
listed.
you can make your mention now.
13.
Yes.
My lord, my friend is also here.
Yeah, what was your case?
My lord, that pharmacy college, my lord, wherein, my lord, the similarly situated persons have been given the NOC for the current year, whereas we have not been given. I'll just take my lord through the writ petition, my lord. My lord may come to, I'm not troubling your lordship with anything else, page 44, my lord.
Yes.
With reference to the letters of the subject cited above, I am directed to convey no objection of the government of Assam in Medical Education Research Department for starting of degree diploma in pharmacy course at the following institute for the admitted batches, that is 2021 and 21-22. Subject to the condition that no further admission for the session 22-23 and thereafter shall be made by the institute without government permission. They shall submit an undertaking to this effect. Non-compliance of this order may invite cancellation of the no objection certificate. I am, my lord, Alama TR College of Pharmacy, Badarpur, Karimganj. Now, my lord, the original is at page 45. Yeah, my lord, will have the same thing, my lord. My lord will have clause 2 at bottom, my lord. The institution shall fulfill all requirements with regard to physical infrastructure, clinical facility and teaching facility as laid down by the government within 1 year from the date of issue of this NOC. Now, my lord, this NOC was given to us on 3rd of June 2022. Now, my lord, will have page 68, running page 68, my lord. Therein, my lord will find similar NOC being granted to three, my lord, pharmacy colleges in the state, my lord. Same condition, my lord. My lord will have 21-22 ex post facto and 21-22. Then they say no further admission in session 22-23. My lord will have clause 2, my lord. The institution shall fulfill all requirements with regard to physical infrastructure, clinical facility, teaching facility as laid down by the government SSUH. Now, my lord, we were waiting, that they will be, my lord, giving us the NOC, but they have not given us the NOC. Now we come to learn, my lord.
For this session.
For this session, my lord, we come to learn that the other 4 colleges, which are there in page 68, they submitted some application. I'm bringing that bit to your lordship notice. Submitted some application before the government, and the government has now permitted them to continue from 22-23. My lord, there is a letter which my friend has placed before my lord on 15/5/23, my lord. My lord has got it. 15/5/23, my lord. It was there on the last occasion. It's a bunch, my lord, like this.
Yes.
My lord has got it. Now, my lord would come, that instruction was directed to be taken, the last but one paragraph, my lord. Accordingly, the pharmacy institutes had submitted their application for the academic session 22-23 and subsequently granted NOC with the approval of the higher authority. As such, government has issued NOC to private pharmacy institute on the basis of their applications. I say, my lord, no such application is required. My lord will see the application. Just, my lord will turn over a page, 2 pages, my lord. That's the application by the colleges, my lord. My lord would have the second paragraph. Same situated like me, my lord. That's how we have submitted a prayer individually to the government in the year 2019 for granting NOC from the session 2021 as required by the Pharmacy Council of India. However, the same could not be pursued due to pandemic of COVID-19. When our applications for grant of NOC was in process, the government of Assam announced moratorium, my lord, that can be just skipped. Meanwhile, in pursuance to government order, the DME was kind enough to conduct inspection in our colleges and submitted its report to the government with due recommendations. That the government was kind enough to issue NOC to the applicant colleges wide letter dated 25/5/22 and 3/6/22 for the session 2021 and 21/22 only. This has also been mentioned in the NOC that no further admission for the session 22-23 and thereafter shall be made by the colleges without government permission. Now the academic session of the current year 22-23 has already been started, and the intending students are putting pressure on us to give them admission so that they do not lose the opportunity to pursue employment generated pharmacy courses. In view of the facts, we would like to request you to kind enough to grant permission NOC to our colleges to enable us to admit the intending students in the first year of so-and-so from the session 22-23 onwards in the larger interest of the intending students. Now, my lord will not find anything about law here. It's just a prayer made. That kindly give us, we'll go ahead. Now, my lord will see the next page, my lord. 3/6/2022. Sorry, my lord. Sorry, my lord. That, my lord, again, my lord, I'll have my lord's attention at page 70, my lord, of that running page, my lord. This is a letter (70), my lord, Annexure 4. The same, my lord, wherein, my lord, I had shown 25/5/22. This is an RTI reply. Therein, my lord would say, reply B, my lord. As per records department, the following NOCs have been issued for the starting private so-and-so for the year 2021, 21-22, 22-23. My lord, till number 6, continuous, 7 is mine. Alama tier of so-and-so for the years 2021 and 21-22 only. Now, my lord, will have a come to page 71, my lord. NEF college was given on 22/5, my lord, 22 for the session 2021 and 21-22. Now, my lord will say this. With reference to the letters on the subject cited above, I am directed to convey no objection of the government in the so-and-so of the so-and-so for starting degree for diploma in pharmacy code to NEF College of Pharmaceutical Education and Research, Jail Road, Noga, from the session 22-23 onwards. So, my lord, they have been given that and they are now continuing. But, my lord, will have clause 2 there, my lord. The institution shall fulfill all requirements with regard to physical infrastructure, clinical facility, and teaching facility as laid down by the government SSUH within 1 year from the date of issue of this NOC. So, this was the condition which was there in the initial one also. Again, it has been, my lord, put in. That means they also have lackings like me, my lord. But they have been permitted, given a, my lord, a upper hand. Whereas, my lord, we have been deprived. And that area, my lord, Barak Valley area, this is the only self-finance institution. So, my lord, my prayer before my lord is maintaining parity, let them give us a similar NOC, my lord. My lord will direct them to issue that NOC. And my lord, onwards, and my lord will keep this matter if required pending. And my lord will consider the issues, my lord. But let us go ahead, my lord. Because the Pharmacy Council has again, my lord, my lord, again approved our, my lord, for the year 23-24, madam.
Where is that?
My lord, I have given it to your lordship. It's a letter dated 35-23, madam. It's Pharmacy Council of India, my lord. My lord has got it. It's a letter dated down below, my lord, 35-23. It says, convey the approval of PCI as per following: BPharm, the affiliating unit, BPharm, government grant approval for 23-24 academic session for conduct of the 4th year so-and-so, allow 100 admission in 23-24 academic session in the first year. The last approval of so-and-so is restored and wide notification read with so-and-so instruction submit affidavit. In view of the above, it was decided to verify the said affidavit during the inspection process of 23-24 academic session. So, my lord, we have been permitted to go ahead and they will come and make the necessary, my lord, inspections. Now, we are not allowed to operate this school, college. When the authority competent is already, my lord, there giving us permission. And the government similarly situated institutions, they are being, why? Because they submitted an application. There is no such requirement of submitting an application after an NOC is given. And none of these colleges had their NOC when they, my lord, started off. So my humble prayer, my lord, before my lord is that in terms of this Pharmacy Council of India approval, my lord will allow us to proceed with the courses. And my lord will direct all the authorities, the Pharmacy Council of India and the affiliating university, my lord, to, if required, to do the needful in the matter, my lord, with regard to the inspections that are called for. It's somebody's ego somewhere being hurt, my lord, because this college has not gone with a begging bowl. That's the issue, my lord.
Yes, go ahead.
My lord, here the issue is, my lord, the petitioner has already placed before the honorable court. I have placed the inspection. There is 15th of May 2023. That month of documents.
My lord, I see that.
Here, lordship will see that page in the 3rd page. There is the application 12th of July 2022. My lord, these institutions, the signatories, lordship will see, my lord, down below. They were granted NOC like that of the present petitioner. Same NOC, my lord, the same conditions as page 45.
Oh, 1 minute. Mr. Nair,
Lordship.
He is not
is it
applying.
necessary that every year you have to apply?
No, It's not necessary, my lord.
On what basis are you submitting?
Because, my lord, NOC is given once and then the matter is taken away by the PCI and the affiliating university, my lord. Government has got nothing to do. And if they have a provision, shows, my lord, that every year I have to go for an NOC. I'm saying from the day one, kindly produce that before this honorable court. So I also know, I'm also educated. There is nothing produced till date, my lord.
Yes, go.
My lord. Now, lordship will see.
Is there a provision that they have to apply for NOC every year?
No, my lord. There is
No.
no such provision, but we can go for inspection. But lordship may kindly see, my lord. Page
Then-
40, no, lordship may see page 45. Page 45 of the writ petition for a moment. Before getting the NOC from the government, my lord, the petitioner started the courses in 2020 itself. Page 45.
Yes.
With reference to the letter on the subject cited above, I am directed to convey no objection of the government of Assam in Medical Education and Research Department for starting of degree diploma in pharmacy courses at the following institutes for the admitted batches 2021, 21, 22, subject to the condition that no further admission for the session 21, 22, 23, and thereafter shall be made by the institute without government permission. They shall submit an undertaking to this effect. Non-compliance of this order may invite cancellation of this no objection certificate. Now here, my lord, the serial number 1, my lord, is the petitioner institution. Now, lordship will see the additional affidavit that has been filed by the present petitioner. My lord.
Where is that? Yes.
In the RTI part, my lord,
Page 70.
page 70. My lord, institutions, my lord, names have been given, who have been allotted, my lord, who have been granted the NOC for the subsequent period also. Now, my lord, 2022-23, in their, my lord, NOC certificates that have been issued by the health department, it has been mentioned as from 22-23 onward. So, my lord, every year part, my lord, is now clear. But in the case of the present, my lord, petitioner, after, my lord, this NOC was issued at page 45, lordship has gone through it, which is the subject matter of the present petition. He has approached his honorable court instead of submitting an application before the authority for granting the NOC for the subsequent years. Others have
No.
approached.
Because you yourself say that there's no provision that they have to apply for NOC every year.
Every year, but in the NOC that was issued to them in this writ petition at page 45, 3rd of June 2022, it is a very specific condition that you cannot go ahead without getting the NOC for the subsequent year.
Where is
For
that
that, what
page 45? Let us
may I
see.
read that para again, my lord? Page 45. Subject to condition that no further admission so and so. Now, my lord, when this was issued, he for the next session, my lord, he ought to have applied, my lord, along with the other, my lord, candidate, other institutions, my lord. What is that big ego, my lord, now, my lord, on his part that he cannot, my lord, approach the authority? And lordship, on the as per direction of this honorable court, the inspection report has been placed before this honorable court in the affidavit, my lord. There are lacunas, discrepancies, my lord, or deficiencies in the, my lord, institution. So at least the petitioner may approach lordship may direct, my lord, considering the parity, whatever lordship wants. But this honorable court cannot, does not have the expertise to see whether an NOC should be granted to the petitioner or not, my lord.
Then what
It's a
happens?
different thing, my lord. Lordship may kindly see the NOC affiliation of the pharmacy council. The latest one, if a copy may be furnished to me, at least I can point out, my lord.
Pharmacy contract.
Or lordship may kindly see page 28 of the writ petition, my lord. For a moment. Page 28, my lord. Annexure 3 of the writ petition. This is the first affiliation that the petitioner got from the Pharmacy Council of India. It was issued on 10th of April 2020.
No, the latest one is
So,
13
Lordship
May
may kindly
2023.
have a look at this for a moment, my lord. Because this is the, my lord, very basis of the, my lord, opening of the institution. by the main, my lord, controlling authority. Your lordship will kindly turn to para 4. In the decision column, my lord, 4. The approval is subject to the following conditions. Inspection will be conducted by PCI. If the inspection report reflects non-compliance of the statutory prescribed norms with regard to infrastructural facilities, teaching staffs, etc., the approval granted will be withdrawn and the entire consequence shall rest on the institution. C. Submission of consent of affiliation of examining authority, that is the university, and NOC of the state government before making admission, failing which approval granted shall be deemed to be withdrawn. So there is a condition precedent, my lord, mentioned in this particular affiliation granted by the Pharmacy Council of India way back in 2020, wherein, my lord, receiving a NOC from the state government where the institute is located or situated or established. But in the present case, my lord, lordship has seen in page 45, the institute started functioning.
Gokul, one issue is this. We have seen
Yes.
the affiliation given. by the
Finally, it
PCI.
has been given. NOC has been given with the.
So you have
retrospective
given your
effect,
NOC,
yes.
whatever it is.
My lord.
The last affiliation given by the PCI,
My lord.
13 May 2023,
My lord.
does it have that condition? No.
No, we are not saying, my lord, this has been issued by the affiliation has been given by the, my lord, Pharmacy Council of India. Let him show the, my lord, rule which says that, my lord, moment Pharmacy Council of India gives the affiliation, the state government is bound to issue the NOC. Let him show, my lord. Where is that in the regulation of the PCI? My friend is appealing for PCI, or this specific query was, my lord, raised by this honorable court. He was directed to have instruction whether without the NOC can the institution function. He may place it, my lord, before this honorable.
Yes, Gogoi.
Lordship, last approval of Lordship on 23 Lordship. I have received the Pharmacy Council of India approval process for academic year 2023-24 Lordship.
Yes,
As per my lord's direction, they have provided this Lordship. The register has sent me that particular document, Lordship. It says that, Lordship, in 5 Lordship, serial number 5 Lordship, during the approval process for academic year so and so for introduction of the new pharmacy courses by existing institution, the institution will have to apply in the portal along with the requisite pharmacy education regulation charges along with the GST submitted below mentioned document mandatory at the time of application for consideration of the application, Lordship. Number 1 is B.Pharm courses, consent of the affiliating of the examining authority, that is the university, Lordship, and B. NOC of the state government, Lordship. And Lordship, it says that in case state government has done away with the issuance of NOC of the state government for the starting of the pharmacy courses, in that case, institution shall upload the said communication from the state government as a documentary evidence. If they have done away that process, Lordship. Otherwise, Lordship, if the state government done away the issuing the NOC process, then the particular institute have to upload that particular document, Lordship. By which documents the state government has done away to giving the NOC, Lordship. Yes, but the submission.
Lord, I'm really sorry. If my lord reads that clause 5, it says if new courses are open, new courses when it started off, that is required. Now it is not required, my lord. Where is that after the NOC has been granted? Fresh NOC every year has to be granted.
No, that is
My
not.
lord, my friends are trying to, my lord, twist the whole thing. It's
No,
not the intent, my lord.
Introduction of new pharmacy courses.
New pharmacy courses.
By existing institutions.
New, I'm not, this is my old pharmacy. This was, my lord, from
This is
2020.
for
running.
B.Pharm
It's
courses
not a
and
new
D.Pharm
course, my lord.
courses, Lordship.
It's not a new course, my lord. B.Pharm is from 2020, my lord. Not in 23-24. My lord has seen page 28. My lord will come to the next document. My lord, that I'm not sure. My lord, that will clarify the issue. My lord will come to the next document at page 33, my lord.
Which this.
No, my lord, the writ petition. My lord has seen that the government approval was required, my lord, in page 28. My friend has placed that. Page 28, my lord has seen that. NOC is required. My lord will come to 33, my lord.
Yes.
BFAM. My lord, granted approval for 21-22 academic session for conduct of second year of BFAM course. Allowed 100 students in 21-22 in first year BFAM course. Permit raise in admission from 60 to 100 from 2021 academic for the academic session BFAM. It is further instituted to full compliance of requirements, or particularly with regard to teaching staff. So, my lord, the same very PCI, my lord, the next very year, in spite of that condition, allowed us the further approval for the next year, and also, my lord, allowed us the intake, increase the intake. Now, my lord, if this was, my lord, granted, what is the significance of that NOC? Because NOC was not submitted. Because on that day, the NOC was not with me. Neither, my lord, I could submit the other document. NOC came in 2021. Now, my lord, the whole question boils down is my application. Now, my application, my lord, what if I just put in an application that kindly give me the NOC? That's exactly what the others have done. So, my lord, there is no law behind this, my lord.
What is this?
This is the document, Lordship, the minutes of the 326 Lordship, the executive committee meeting of the council, Lordship, Pharmacy Council of India, Lordship, where it says that, Lordship, last paragraph B, Lordship, B small b, Lordship. B says that regarding, Lordship, the verification of it's a subject matter, the item is, Lordship, regarding verification of statutory documents submitted by institutes in appeal or grant of approval of the council secretariat in respect of institution where decision were upheld by 109 Central Councils, April 2020 for want of the same, Lordship. Then it says that, Lordship, B, Lordship. Consent of the affiliation of the examining authority is submitted in respect of BFAM courses because in some states, the state government have done away with the issuance of the NOC to the institution. Hence, if the examining authority has the issue the consent of the affiliation, same be accepted as fulfillment requirement of the statutory documents for BFAM courses. If
And
the
here-
state authority done away, Lordship, for issuance of the NOC, then, Lordship, the affiliation universities, affiliation is taken for issuance of the approval of it.
My lord will record that, my lord. Let my friend's statement be recorded. That
is there,
if
it is
there is,
there.
no, I'm not saying, no, let it be recorded, my lord. If they say that this whole school should not be operated, my lord, let it be, my lord.
Wow.
Now, Lordship may kindly see the affidavit that we have filed pursuant to the order of this honorable court. That affidavit is dated 30/3/2023. It is filed.
My
by
lord,
Colonel
I'm not sure why this documents are being, my lord has that document, my lord, this document, my lord will just peruse with me, my lord. Applicable in respect of new institution applied for introduction of new course from 2020-21, which have neither submitted document so and so effect that they will submit the prescribed before making admissions. While submitting appeals under some institutions have submitted the above prescribed documents. It was decided that verification of the documents be done at the council secretariat level and approvals be granted and uploaded on council website for appeals under so and so. Only in case of affiliation of examining is submitted in respect of so and so. Consent of affiliation is submitted in respect of before, because in some states have done away with the NOC. Hence, if the examining authority has issued the consent, now, my lord, this is because of colleges like us. At that point of time, we did not submit the NOC. Subsequently, we have submitted the NOC, my lord, and that is why in the latest, my lord, there is nothing. This is a general thing given for all institutions, my lord. It's not specific to my institution, my lord.
My lord, it is regarding the session 2021. Lordship may kindly see that.
Yes, I am also saying 2021 only.
Session has started in 2021.
Yes,
So,
I have given
NOC
that.
is otherwise required.
No,
Now,
you
my lord,
should-
nobody is saying that, my lord, he will not be granted the NOC. There is not a single statement made by the.
Then, my lord, let them
department.
grant it, my lord will direct that, my
So
lord.
how
That's
can
what I
this
am saying.
honorable court, my lord, step into the shoes of the executive, my lord?
Yes.
Not the issue. my lord.
I'll answer to that, my lord. My lord, why they say,
No, everybody will come and, my lord, approach this honorable
no,
court and
let
grant
them,
an
let,
NOC. My lord,
my
why?
lord, this is the letter given by the four institutions.
My lord, let him either
Making a
complete the
prayer, give
submission,
me.
then I will make the
There is
submission,
nothing
my lord.
law
In
here,
between
my
my submission, why is my
If
lord?
that is the way you give, then what is the harm in this honorable court directing, my lord?
Now we'll take up the after tomorrow. There's no time today.
My lord, can it be the first item? Because, my lord, otherwise the whole thing will be frustrated, my lord.
Yes.
Lordship.
Otherwise, we can issue an interim order.
Lordship,
The interim, my lord, that is the final order. How can my lord, that can be a.
my lord will
interim
issue
can
an
be a final
interim
order.
direction. My lord will
Granting of
direct them
NOC
to
is the
give me
final
an NOC at par with the others, my lord. That much only I am
Lordship,
saying.
but
I am
you can hire
submitting
the
before his honorable
senior
court that
counsel.
direction may be given to the authorities to
Sir,
consider, my lord. Where is the bar?
MZ Patel and the counter for petitioner also heard B. Gogoi, Leonard Standing
Full
Counsel,
resolution.
Health Department.
Health department, my lord.
And Mr. Gay Gogoi, Leonard Standing
I'm
Counsel.
from Pharmacy Council of India, Lordship.
Responder number?
6, Lordship.
Responder number 6. Please the matter, get on,
Thursday, my
20 seconds.
lordship. My lord, I'll make a mention for upgradation.
Okay, okay.
Much obliged.
My lord,
No.
item number 23 is not, may pray, my lord, matter be fixed day after tomorrow, but some urgency is there with regard to the admission, my lord.
Request made by PG Cycle and Senior Counsel. Please the matter. Day after tomorrow, I'm having a lot of cases.
In that case, my lord, on 27th, my lord, 27 June,
Okay, 27.
I'll mention the.
My name may be recorded. My name may be recorded. For
Mr.
NCT.
I allow the council appears for the NCT. NCT, isn't it?
LCT.
My for Dibrugarh University, R. Mojumdar.
And Mr.
N. Sharma on behalf of R. Mojumdar.
And Simon.
Dibrugarh University.
R. Mujumdar for the Dibrugarh University.
Lordship,
Can I
13, 14,
have-
15, 14, 15, 16, Lordship.
Yes,
For- So Lordship may already heard a matter, Lordship, twice.
I've heard, I'm yet to hear Chowdhury.
He has already submission, Lordship.
Lordship, I have already, the director has passed the speaking order. But the
We'll take it
inspector,
up, we'll take it up some other day. Then I'll pass orders, otherwise there's no time now to pass orders. We'll have it on Monday, 26. List these matters on 26.
Part heard, Lordship.
Not part, it will come up.
Item 20 and 21, my lord, date may be fixed. 20 and 21.
After summer vacation.